Good morning, ladies and gentlemen. This is the December 8, 2021 regularly scheduled meeting of the Board of Adjustment of the Municipality of Anchorage. I'm Bernd Judicial, the chair. Madam Clerk, would you please call the roll?
Yes, Mr. Chair. Mr. Judicial.
Here.
Mr. Dean.
Here.
Mr. Stewart.
Yes.
You have a quorum.
Thank you, Madam Clerk. I should also mention that the clerk that is here today is Jennifer Venneklassen, who is Deputy Clerk in the Clerk's Office of the Municipality of Anchorage, and our esteemed lawyer, Dennis Wheeler, is also present. The first item on the agenda is to approve it, and so I would like you to quickly look at the meeting agenda that has been handed out and see if there are any objections, any additions, deletions, changes that you wish to make. Mr. Deek?
No, sir.
Mr. Stewart?
No change.
And I have no change, and I assume, just in the interest of expediting this, that means that the agenda is approved. The next item on the agenda is that we need to consider the minutes of the meeting of October 20, 2021. We all have received a draft of that, and hopefully all three of us have had an opportunity to review it. Are there any changes, additions, deletions? I must add that Mr. Stewart is always good at details, and so if there is a comma missing or the vote is recorded incorrectly, I'm sure Mr. Stewart will catch it. So let's turn to him first. Are there any additions, changes, deletions that you see?
I have not in my cursory review of this.
Are you saying there are none, or do you say you wish to have more time to consider them?
No, I've read through there, and to the best of my recollection, that this is exactly it reflects what we went through in the motions, et cetera.
Okay. All right, thank you. Mr. Deek?
Mr. Chair, I believe the minutes captured what the actions of the meeting, so I would support an approval if we actually have a motion to do so.
Okay, and I have no changes, additions, deletions, so Mr. Deek, since you appear to offer it, I take it you are making the motion
I
to
am.
approve the meeting of the minutes of October 20, 2021. Is that correct?
That's correct, yes.
And Mr.
Second.
Stewart, you will second that.
Second.
Is there any discussion? If not, there is no reason, again, in the interest of expediting things, seeing no objection, the motion is passed unanimously. The next item on the agenda is old business, and there doesn't appear to be any, at least not that I'm aware of. Mr. Deek, are you aware of any old business items that we need to address before we get into the meat of this matter?
No, Mr. Chair, I am not aware of any.
Okay, Mr. Stewart?
None.
Okay, and I have none either, so the minutes should reflect that there is no old business that needed to be attended to at this time. We come then to new business, item number 6 on the agenda, and that concerns the consideration of BOA appeal number 21-2, Planning Board case number 12599, amendment to S12420 Spruce Terrace subdivision lots 1 through 27, phase 1 through 3. Now, we all have had we have had time to consider all items. There are some preliminary issues that need to be addressed, and so I think just so that you know where I wish to go here today, so that we get done in the time that is allowed today and don't get hung up on details, is that we consider the preliminary issues first, and I have on my agenda 6 preliminary issues, and then we deal with the substantive issues on appeal. Is that agreeable to you, Mr. Deek?
Yes, it is.
Okay, Mr. Stewart?
Yes.
Okay. All right. So then we will immediately move to the first item, and that is what I myself raised, and that is the missing page 5 of the staff presentation, and specifically the staff analysis, page 5 of the staff analysis. As I was going through it, I discovered that that was missing. And so but the way to address this, I think, is that our attorney has looked at this, and while staff and the planning department have said that the page was not part of the public record presented to the planning board during its deliberations, planning also said that the content of the page, but not the page itself, is in the record. So I will make a motion to disregard the missing page 5 of the staff analysis, in this case, Appeal 21-02. And I would like to have a second to that motion.
Second.
And it has been moved by myself and seconded by Mr. Stewart to disregard the missing page 5. Let me address this issue very briefly. I intend to vote in favor of this motion. And the reason is that while the page itself was missing, the contents of it was part of the record in pages R358 through 360. And it is available by way of the record that we have in this case, the record on appeal. And incidentally, I need to correct myself. Apparently it's at R358 and R359. So it is for that reason that although the verbatim provisions of page 5 are not there, the substance of it is there. And it is for that reason that I think we can safely disregard the missing page 5, and I intend to vote in favor of the motion to quietly, or maybe not so quietly, disregard it. Mr. Stewart.
I agree with that, because what is missing, and I've looked at it in detail, is it's the same wording that was cut and pasted, or that should have been cut and pasted in the staff analysis that is at 358 and 359 of the record. So I don't think that missing page has any impact, because it is reflected in the paragraphs at R358 and 359. I intend to approve, vote and approve.
Thank you, Mr. Stewart. Mr. Deek, any additional comments?
Oh, maybe the only comment I have is that that the process in which the agencies comment is either provided in the back as a summary in the planning action, or provided there and also put into the summary by the staff preparing the documents. And in this case, all of the contents starting at the last 3 bullets on R358, and then the first 3 bullets on R359 are the missing elements, and they are in the record by commenting by private development commenter, so they are available for us. So I would support the motion to not make a matter out of missing page 5, to make it complicated.
Thank you, Mr. Deek. I have no further comments. The motion motion should, or the record should reflect that the motion is supported both by Mr. Deek, by Mr. Stewart, and by myself, and it is based, the vote is based on our comments and on our review of the matter. Now, before we vote, Mr. Wheeler has a comment. He's raising his hand.
Thank you, Mr. Chairman. I noticed Mr. Stewart raised his hand too, so if Mr. Stewart would like to go first, then I would follow.
Okay. I would also note that the summary of actions at the record 299 through R302 restated the conditions, and the minutes also included the restated conditions at A312 and 313, along with that staff analysis that restated. So it's actually been restated 3 times within the record.
Okay, thank you. Does that raise any additional comments, Mr. Deek?
No, it doesn't.
Okay. Mr. Wheeler?
Mr. Chairman, I'd like to add to the record on this issue that the appellant did raise the missing page in the footnote 9 of their notice of appeal at R004. So the appellant was aware of the missing page, but did not raise that missing page as a distinct issue in the appeal. And as I noted in my brief to the board, it doesn't appear either party made the issue of the elements that are missing in that page part of their appeal and response.
Okay, thank you. Does that raise any additional comments, Mr. Stewart?
No.
Mr. Deek?
No.
I don't have any additional comments. Madam Clerk, would you please call for the vote on this?
Yes, Mr. Guchow?
Yes.
Mr. Deek?
Yes.
Mr. Stewart?
Yes.
And the record should reflect that the motion to disregard missing page 5 passes by a vote of 3-0 and is based on the comments of myself, Mr. Stewart, Mr. Deek, and our attorney, Mr. Wheeler. Next item, before we get to the items, by the way, in terms of procedure, I don't know if you recall how I like to do things when we make motions. They need to be worded in the positive, so that when we come to the positive in favor of the appellant, so that it is clear from the record later on what we addressed in our motions and how we viewed the appellant's arguments. So the next matter then is the exclusion of certain exhibits. Now, this issue was raised initially, I believe, by the FLE in his brief, who stated that a number of exhibits should be excluded, and the specific exhibits that should be excluded are exhibits 1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, 34, and 35. And that contention is contained in FLE's brief at pages 1 and 2. So, by way of handling this, I would like to entertain a motion to include the exhibits that I just mentioned, that is exhibits 1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, 34, and 35. So the motion is to include those exhibits in the record because they are contained in the notice of appeal. May I have a person please to indicate that he will make that motion? Mr. Deek, thank you. And Mr. Stewart, are you willing to second that
Yes.
motion? Okay, so the record should reflect that a motion has been made by Mr. Deek, seconded by Mr. Stewart, to include exhibits 1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, 34, and 35. All right, Mr. Deek, would you address the motion, please?
Yes, this motion is about including materials which were in the filing of appeal and not directly part of the record on which we are supposed to make judgments. And it's a long list of items. I'm not going to do the same thing Mr. Chair just did 3 times. Some of those items are material which are specific to the project, and some of those are more wide-ranging, like studies and materials available through the website, through planning department, or district plan alternatives, and a wide range of materials. An issue is that is this the proper form to include evidence into our processes, and is this the way to include these materials into this proceeding? And I do believe that our record, our call is that we act on the record. These materials are not specific to the record, and in that light, I would be careful to act based on our call, which is not to include them. And there's a long list of items here, and I would like to just make one note on that, is that some of this material is material which is indirectly available to the planning board as they act, for example, parcel information and other materials, but they are not directly included in the record. And even with that knowledge, I would say that it is probably not prudent to our proceedings to include them.
Thank you, Mr. Deek. Mr. Stewart.
Some of these, well, as Mr. Deek stated, that some of these exhibits are in fact probably questionable as to whether they should be included in the record, and some, on balance, should be included, but I think it's going to take additional analysis on each set as we go through these, because there's a lot of information in there that we need to consider. But so far as this motion is concerned, some of the elements, I think, are appropriate, and some may not be appropriate.
So how do you intend to vote on the motion?
Well, the motion was to include all the exhibits 1 through the long list, since they are part of the appellant's filing. And normally that is the case. But in this case, I think there's some in there that we need to look at individually in order to make a decision on this particular motion. So what I'd like to do is look at these series of exhibits and make some individual decisions on them, and then come back and look at the motion here as to whether or not the motion is approved, or whether it's denied, or whether it's approved with conditions or exceptions.
Okay. So you're not prepared to vote on the motion at present?
I would prefer not to at this time until we get more into the details on each one of those exhibits.
Okay. Let me, as the third member of the panel, weigh in here. The appellant argues that since they were attached to the notice of appeal, and that's what we are talking about, they are part of the record. To my way of thinking, that is not the proper way of addressing the issue. If the record could be, if in fact it is true, and I think we have to accept the appellant's statement that it is all contained in the notice of appeal. The purpose of the notice of appeal is to make specific allegations and to state basically to this board that the decision of the body below is challenged for specific reasons. The notice of appeal is not designed to provide proof of alleged allegations. That's why you generally find that a notice of appeal is maybe 2 or 3 or 4 pages long. In this case, however, it is enormously long. And what really the appellant has done is he has provided and has really incorporated into the notice of appeal its opening brief so that it's basically one and the same. If the record on appeal, well, let me backtrack. The ordinance that gives us the authority and the direction to consider an appeal states specifically that it is to be based on the record that is before us. And the record before us consists of various matters, but it does not include the notice of appeal or anything that is attached to it. If the record could be supplemented simply by allowing any desired evidence to be attached to the notice of appeal, it would constitute an end run around what we are required to consider and what we cannot consider. And so it is for that reason that the notice of appeal is not a mechanism by which to introduce evidence into the record on appeal. That's really my point. And that's what the appellant has tried to do here by attaching these various exhibits that I've mentioned at the beginning to the notice of appeal. And I do not think that's appropriate. It would invalidate really what we are required to do, which is to consider only what is before us, not what is surreptitiously added by a party to the appeal by way of attaching it to the notice of appeal. So it is for that reason that I intend to vote against the motion. Now, having said that, Mr. Deek, you're the one who made that motion. Does that lead to further comments by you regarding the motion?
I would like to add one comment, and that is I am in support of adhering to our call in the ordinance. And this mechanism to introduce evidence is clearly not part of that call. On the other hand, I would like to express, and I'm probably going to do that a few times today, is that the process has been an issue on this case. Several times we heard about, as we get into this case further, about how the planning board's actions are viewed by the public and how the reaction of the appellant is basically in a perceived or real disadvantage in acting. In this case, what we see is that the preparation and the further study of the case prompted the appellant to provide evidence which could have been reasonable at the planning board meeting or at the time when the actual case was considered, and perhaps would have had some impact in terms of the decision. But in our call, in our somewhat narrow call for a process, I do believe that this is not the proper way to have evidence introduced into this record, because it's clearly not part of the record. So in that regard, I will stick with my original statement I believe I made earlier, which is that I will not support the motion to include this evidence.
Thank you, Mr. Deek. Mr. Stewart, does that elicit
Yeah.
further comments?
Can I have that motion read back?
Right. The motion is to
To include
to include exhibits
And
1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, and 35.
As new evidence into the record.
I'm sorry.
Would you like to include 34 as well?
Yeah.
Yes.
and what was the last part of it?
To include into the record as a new evidence.
It's new evidence, yes.
Okay. That, I missed that part.
I'm so sorry. All right, does that elicit further comments by you?
Okay. That, because where I was going with this is I was going to ask to amend the motion so that it would address, it would say that they're automatically included in the record because they were attached to the notice of appeal.
Well, that's part of
Something
the
like,
motion.
and that's basically
Yes.
what you're saying here.
Yes.
Okay. Then I'm prepared to vote on this now, and I'm prepared to support it because this is new evidence, and it's not automatic. So I'm prepared to support it.
Okay.
Mr. Chair.
Mr. Deek.
Just one correction. This is a positive motion by inclusion. So I will not support it. I just want to restate that.
Thank you. All right. Mr. Stewart has stated that he is prepared to support the motion. I am
I'm
not.
sorry.
Mr. Stewart.
No, I'm not going to support it because I agree that there is no proposition for automatic evidence being added as part of the appeal notice.
Okay. All right, so you're prepared to vote no on the motion, I take it?
Yes.
All right. And I should state for the record that for the reasons stated by me before, I will vote no on the matter as well. So, any additional comments? Are we ready to vote on the matter? If so, the record should reflect that this motion is supported by the comments made by Mr. Deek, Mr. Stewart, and myself. Madam Clerk, would you call the roll?
Mr. Guchow?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
And the record should reflect that the motion fails by a vote of 3 nays and 0 yeas. Next thing then is that the appellant says, well, if you will not include it for the reason that it was attached to the motion, to the notice of appeal, you should at least allow it to be considered on the basis of judicial notice. You should take judicial notice of these exhibits. And so in order to bring this matter forward, I will entertain a motion to take judicial notice of exhibits 1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, 34, and 35. Mr. Stewart, are you prepared to make that motion or no? If not, I will simply.
No, I just would ask you to, I've got mine lined up in a different way, so would you go over those again?
All right. It is to take judicial notice of exhibits 1, 6, 7, 10, 11, 12, 21, 25, 26, 27, 28, 29, 30, 31, 34, and 35, and include them in the record by way of judicial notice.
So moved.
Thank you. I will second that motion. All right, Mr. Stewart.
Hang on just a second.
Sure. Take your time.
Mr. Chairman?
Yes,
May I offer a
Mr. Wheeler.
suggestion?
Yes.
So I broke those exhibits into 3 categories. I believe Mr. Stewart may have done the same in his notes. So
Well,
I don't know if your intention is to then follow up with this motion with sub-motions related to each of the 3 subcategories?
That depends on how this main motion comes out.
Okay.
So if the motion is approved, we will need to break it into several parts. If it is not approved, then that takes care of the matter right then and there, and we don't need to break the various exhibits into groups. Okay? So, while Mr. Stewart collects his thoughts on this, let me simply address this matter. As the second, my view of the matter is that the judicial notice issue is reflected by the rule of evidence that is in existence here in Alaska, both on the state level and the federal level, and it is Evidence Rule 201. The appellant argues that they are all relevant and all exhibits are relevant, and the Board of Adjustment could take judicial notice of them if they are not part of the record, that they are relevant for various reasons. But to my way of thinking, that is not the case. The rules of evidence that provide for judicial notice, and it's contained in Evidence Rule 201, which is the same in Alaska as federal level. It basically governs judicial notice of fact. Judicial, and I'm reading from the rule itself right now. Judicial notice of a fact is used in this rule means a court's on-the-record declaration of the existence of fact normally decided by the trier of fact without requiring proof of that fact. And the general rule is that a judicially noticed fact must be one not subject to reasonable dispute, and that it is either one, generally known within this state or to this board, or 2, capable of accurate and ready determination by resort to sources whose accuracy cannot be reasonably questioned. Now, the difficulty with this is, and the rule addresses this also, is that this matter was first raised by the appellant in his reply brief, and while the appellee stated in his opening brief that these particular exhibits should be excluded because they are not part of the record, the appellee never had a chance to address the argument that even if these exhibits should not be included because they were part of the notice of appeal, the concept of judicial notice applies. The appellee never had a response to an opportunity to respond to that. And the Evidence Rule 201 specifically addresses that. And it says, if the requesting party furnishes sufficient information and has given each party notice adequate to enable the party to meet the request, then you can and perhaps should take judicial notice of the issue at hand. Well, as I said, the appellee never had an opportunity to do this, number one. Number two, what is offered here by way of these exhibits are snippets of documents, not entire documents. So even if we were to admit these documents into the record on the basis of judicial notice, we don't really know what the entire matter contains. It is just a portion that has been attached, and that is not the purpose of judicial notice. So to my way of thinking, for 2 reasons, the motion must fail. First of all, because the appellant did not give the appellee an opportunity to respond to the argument that we should admit these specific exhibits on the basis of judicial notice. That's number one. Number two, the exhibits themselves that have been offered are only part of the entire documents, not the documents themselves. So it is for those reasons that I intend to vote against the motion. Having said that, and being the second, we now turn to Mr. Stewart, who made the motion in the first place.
You summarized that very well. But the basic thing that I was looking at was these exhibits, when they looking at them standing alone, do not meet the requirements, as I deem it, for us to invoke the policy of judicial notice of these exhibits. They're not codified. They're not something that is universally accepted through statute. The laws that are passed, ordinances, regulations, and I agree with the other point that you made, is that the appellant provided these without getting them in front of the planning board so that the appellee could have some recourse to rebut, to review and rebut if necessary. So I will not be supporting the motion.
Thank you, Mr. Stewart. Mr. Deek, any comments?
Yeah, I do have a comment, and I start with the statement that I do believe that both of your summaries basically capture the process, which in my view is that reflects what I think about it, which is that this is not this particular case in with these exhibits doesn't necessarily warrant us to take judicial notice of these exhibits. But what I do want to again emphasize is that the issues are stated in a way that they poke at a larger concept regarding the planning board and its action and its process and its way of doing business, which is not specific to the case we are looking at, but it has perhaps consequences of how they do their work in the future or how they do it in general. And that is, I think, a relevant issue. I do believe that it's not a relevant issue for this particular case to our call. So that, I guess, conflict, if that's a conflict, would be something I would like the record to show, because we do want the planning board to act based on their call, to do it in a way that it's properly grounded in the applicable laws, and it doesn't cause us to have to educate projects, which are really physical constructs based on process and based on constitution of the board and membership and all that, because that opens a problem for our and for the municipality's functioning of orderly development, and it's a concern to me. But I do believe it's not part of this particular case. In this matter, I would also go with both of your opinions that I would not support the inclusion.
Thank you, Mr. Deek. Any additional comments regarding the pending motion? Mr. Stewart, anything else you
No.
wish to add? And I have nothing to add, and I assume Mr. Deek, having just spoken, has nothing further to add at this
Nothing
point.
further.
Okay. So the vote on this motion should reflect the comments by Mr. Stewart, who made the motion, by myself, who seconded it, and by Mr. Deek. Madam Clerk, would you please call the roll?
Mr. Guchow?
No.
Mr. Deek?
No?
Mr. Stewart?
No.
Thank you, and the vote reflects that the motion fails by 0 yeas and 3 nays. All right, so then we come to the next items, and that is that there are certain exhibits that have not been objected to by the appellee, and presumably the appellant wants these exhibits included either because they are part of the record on the basis of having listed them in the notice of appeal or on the basis of the concept of judicial notice. And what we are talking about specifically now are that, I hope I got this correct, we are talking about exhibits 2, 3, 4, 5, 8, 9, 13, 14, 15, 16, 17, 18, 19, and 20. And basically what that is it's the counterpart to the other exhibits that we have already excluded. Okay, so these are the remaining ones that the appellant says should be included either on the basis of the inclusion in the notice of appeal or by way of judicial notice. And to bring this matter to the floor, I will make a motion to include the exhibits that I have just listed because they are contained in the notice of appeal, or alternatively on the basis of judicial notice. And that's the motion I am making, and I need a second for that.
Would you repeat the list again?
Yes. 2, 3, 4, 5, 8, 9, 13, 14, 15, 16, 17, 18, 19, and 20. And the way I came up with this list, by the way, is that when you look at the exhibits that were specifically objected to by the appellee, and that we already moved on, this is simply a matter of subtraction. Okay, so these are the remaining exhibits that the appellant wants us to include for one of two reasons. Either because they were contained in the notice on appeal, notice of appeal, or alternatively on the basis of taking judicial notice of it. And 22, 23, and 24. You are
Yes.
absolutely correct. And Mr. Wheeler just hands me a note saying that my recital of the numbers of exhibits failed to list exhibits 22, 23, and 24.
Thank you.
So the motion is,
Yeah, got it.
I'm restating my motion to that extent so that those three exhibits that I just recited are included in the list that the appellant wants us to include, either on the basis of having them listed in the notice of appeal or on the basis of judicial notice.
I would second that.
Thank you, Mr. Deek. Just let me make some notes. Do you want to go off the record for a second? Is that what you wish to do, Mr. Wheeler? Do you have a question regarding the motion?
Yes, sir.
All right. Mr. Wheeler has a question regarding the motion that I made. Go ahead, Mr. Wheeler.
Thank you, Mr. Chairman. As I understand your motion is to include these either because they were attached to the notice of appeal or because of judicial notice. The first part of that, saying that they're included, or may be included because they were simply attached to the notice, I think is contrary to your prior motion, which excluded them, because you made the point that you can't just automatically include the exhibits and get them into the case simply by attaching them to a notice of appeal. So
Mr.
you
Chair.
may not want to include that first part of your motion, if I understand your motion.
Okay. Mr. Deek, before I respond to that, Mr. Deek.
Yes, so I was gonna get into that, but being on board, I usually am patient enough to listen to the motion and just duke it out when it's already on the floor. So I wonder if we want to do that after, since it's already on the floor, since this is the time to do it, or offer amendments when we go into it. It's more of a process question, but I think Mr. Wheeler is raising a valid point.
And again, Mr. Wheeler, your point being, I'm sorry, I took notes here.
Mr. Chairman, if I understand the motion correctly, the issue is, does that conflict with the earlier motion that says you cannot bring in new evidence simply by attaching exhibits to the notice?
Okay. All right, so my response to that is, and I think Mr. Deek is addressing the same issue, to my way of thinking, there is no conflict there. If we vote in favor of the motion, those exhibits are admitted either on the basis of them being in the notice of appeal or by way of judicial notice. If, on the other hand, the motion is defeated, then those exhibits will not be included in the record for any reason whatsoever, and that specifically is, in this case, because of the attempted end run around including matters in the appeal record, or by way of, or because judicial notice is not appropriate in this case. Does that clarify things for you?
Thank you. It does.
It does. Mr. Deek, does that clarify things for you or not?
Well, since we are in the discussion phase, that it certainly helps to advance that dialogue for sure.
Okay. The reason that I made this motion is because it seems to me if we do not address these remaining exhibits, they are left dangling. And the record of our proceedings here today will not be clear whether those remaining exhibits are part of the record on appeal or whether they are not. And so it is for that reason that I thought, being the methodical guy that I am, we need to address this issue and close the door one way or the other. We either include it in the record or we exclude it. And so that's what my motion is aimed at. And by way of stating, since I'm the one who made that motion, I can tell you that I intend to vote against the motion for the reasons that the previous two motions stated. It's not appropriate to supplement the record by simply including items in the notice on appeal, number one. And number two, it does not satisfy the standards of judicial notice by which we can admit items. And it is for that reason that I intend to vote against my own motion. And that would take care of exhibits. And now let me read this list again, because I followed this up the first time around, apparently. We are talking about exhibits 2, 3, 4, 5, 8, 9, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, and 24. All right, Mr. Deek, any further comments regarding the motion?
Yes, I do think that we may want to refine a little bit of the motion by an amendment to specify your intent. As stated, and Mr. Wheeler mentioned the issue that the motion does look like totally contrary to the previous motion we just acted on. So I think if we include an intent statement according that making the motion to include the listed exhibits because they were part of the appeal, but not addressed in the previous motion, either by a judicial notice or by inclusion. That would be what I would offer as a perhaps refinement for your motion statement.
Okay. Thank you, Mr. Deek. Mr. Wheeler, do you have some specific language that should be added to the motion to satisfy Mr. Deek's concerns?
Mr. Chairman, after your explanation of where you're going with this motion, I'm actually okay with the way the motion is currently. That is to say, the original motion back some many minutes ago was focused on a certain segment of exhibits, and you said those cannot come in as attachments to a notice of appeal and then be admitted solely on that basis. You're repeating that same statement here relative to these specific exhibits. So actually, as I think about it and as you explained it, I no longer object to the way you stated the motion. I'm not object, but I'm no longer concerned about the way you phrased the motion.
So would you repeat it then? So we just simply state that?
Yes, through the chair, Mr. Diak, the original motion was focused on a certain segment
Yes.
of exhibits, and in that motion, with your no vote, you said you cannot bring those in.
Correct.
Simply by attaching them to a notice of appeal. Now, these remaining exhibits are going to get the same treatment. There's a motion that, depending on how you decide, will say whether you can bring those in simply by attaching them to a notice.
Correct.
So the way he's framed it works for me, because he's saying either you're going to agree that they can come in that way and or with judicial notice, or they can't come in at all.
So the language would then, of the motion would state, if you could repeat the language of that, so it's a very succinct, not to release every one of the exhibits, just the actual statement of the motion.
I move that we either admit those specific exhibits on the basis that they were included in the notice of appeal, or on the basis of judicial notice, and that they are part of the record on appeal for either one of those two reasons.
Thank you. That clarifies it.
All right. And since you seconded that motion, how do you intend to vote?
I am intending to not support the motion for the reasons stated for the other exhibits. I would definitely like to be consistent with the view we expressed in one of the motions, and I think in my view, that's the correct interpretation of our call. And I will not support the motion for the same reasons, but I not supported the motion in the previous instance for the other exhibit.
Thank you, Mr. Deek. Mr. Stewart, we have not heard from you regarding this motion at all.
Just a couple of questions. Did you mean to disregard 32 and 34?
Those were covered by the previous motions. 32 and 30.
No, they are not.
They are not.
32 and 33.
So they need to, the
I
record
mean, 32
should.
and 33, yes.
Yes.
32 and 33, so the record should reflect that those are added to the list. So in other words, my original motion really has been supplemented, and I have accepted it. That also added are exhibits 22, 23, 24, 32, and 33. Is that correct, Mr. Stewart?
Yes.
Thank you. I think we finally got it right.
Now, I have one other remaining question. What is the impact, if any, on the appellant's notice of appeal if these are deleted?
Well,
Because
go ahead.
I'm looking at it is, you've got the notice itself, which is one page, and then it indicates on there that he needs to, or the appellants need to include the specifics as to why they are appealing. Does that then make that, are we putting ourselves in a position where that appeal becomes invalid or incomplete?
Mr. Chairman.
Mr. Wheeler.
Mr. Stewart, it does not invalidate the appeal. What it means is that any argument made by the appellant that relies on these exhibits may or may not be insufficiently supported by the record, by the evidence in the record. There may be other evidence in the record that supports their arguments, or some arguments may have no evidentiary support. So as you go through the issues, you'll have to decide whether there's any
Okay.
evidence in the record that supports an argument. But you cannot use these exhibits should
So
you choose to
would
exclude
the
them.
clerk accept the one-page appeal without anything else?
Through the chair, Mr. Stewart, the notice of appeal is not required to contain elements of the record. The record usually isn't even prepared at that point, right? But
Yeah.
So they do have to make
He
arguments.
submits the transcript as part of the appeal.
Correct. In this case, they have done more than just a one-pager. They've actually attached that long letter that makes all their arguments. They've made their arguments. The question now for you is, assuming the exclusion of all of these
Okay.
exhibits, is there evidence in the record to support any of their arguments?
I wanted to make sure that we weren't impacting something that
I
I was concerned with.
Okay. I don't think we are. Anyway, any further comments by you, Mr. Stewart?
No, I intend to vote against the motion.
Any further argument, Mr. Deek? Anything
No.
further?
Nothing further.
Mr. Stewart has nothing further. I have nothing further. Mr. Wheeler, any words of wisdom before we vote on this matter?
No, sir.
Okay, all right. Then I think we are prepared to vote on the motion to admit exhibits 2, 3, 4, 5, 8, 9, 13, 14, 15, 16, 17, 18, 19, 20, 22, 23, 24, 32, and 33, either on the basis that they were attached to the notice of appeal and thus a part of the record, or on the basis that they should be accepted on the basis of judicial notice. Madam Clerk?
Mr. Guchow?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 3 nays to 0 yeas. So we are then, and I'm looking at the clock, moving ahead to preliminary issue number 4. And that is the assertion by the appellant that there is a violation of procedural due process because the planning board failed to give interested parties an opportunity to ask questions in violation of AMRC 2111-302C. And by way of bringing this matter to the floor, I will entertain a motion that the planning board violated appellant's procedural due process rights by failing to give interested parties, including the appellant, the opportunity to ask questions of staff or applicant in violation of AMRC 21.11.302C. And may I have someone please make that motion?
I'll make that motion.
Lord, thank you, Mr.
And
Dean.
I would like to add that, I don't know if you can shorten this particular motion, but the issue is, just as you stated, procedural violation of the alleged procedural violation by the appellant, stated by the appellant.
Yes. Mr. Stewart, will you be seconding that motion or not?
I second the motion.
Okay. Mr. Deek?
Yes, Mr. Chair, this is, again, one of those where the actual record we are looking at doesn't support any of the allegation in terms of the planning board explicitly excluding any kind of ability to comment or ask questions. Now, that is based on what the record shows to me, at least, and I see no issue there in terms of how they have been conducting their process. So I would say that I find no support for this allegation, and then back to that earlier comment I made that again we are back to an issue which is procedural in a sense of how the planning board functions. I do not know whether there is enough education for the public to know that this process exists where you can request a chair for questions, have a process to do that, and then do that during the public hearing, which is not necessarily the issue at hand in terms of the narrow look at the process or the project. But at the same time, it's a larger context, which we have seen several times in this appeal, that maybe the process of the planning board as its functioning may not be properly adhered to. I do not see anything in the record which will tell me that that the planning board acted in a way that restricts anybody's ability to ask questions or address the project at the hearing in any manner. And that's the current record, and for that reason, I don't think I can support the motion.
Thank you, Mr. Deek. Mr. Stewart?
Yeah,
If you wish to take some time to think about this, I will address the issue myself, but if you're prepared to talk about the motion that you seconded, please go ahead.
I'd like to say that the appellant had the option of submitting questions, could have submitted them before the hearing started, and had them in front of the chair when they started the meeting, or he could have made a request during the meeting. And I think when he says his due process is violated, I don't think there's any way that we cannot say that the appellant waived, or we can't say that the appellant waived his ability to make these motions or make submit questions to the chair. So I think there was plenty of opportunity for him, but I think the appellant waived his very accusation that he's making.
And what does that mean in terms of voting on the motion, Mr. Stewart?
I intend not to approve the motion.
Thank you. I join the comments made by both Mr. Deek and Mr. Stewart, and I intend to vote against the motion because basically the issue was waived. While the section cited correctly gives an interested party the opportunity to ask questions, it may very well be that the appellant and members of the public were not aware of that right. But the issue really is that the appellant is now complaining about it after the fact, after having perhaps studied the code and the regulations. But this issue was never brought up at the time that the matter was considered by the planning board. And so for that reason, I agree with Mr. Stewart that this matter was waived by the appellant, and I intend to vote against the motion for that reason. Any further comments? Mr. Deek, you made the motion.
I do not have any further.
Mr. Stewart?
Yeah, I just wanted to double check that section that you referred to.
Yes, 2111.302C.
Okay, got it.
Any further comments regarding the motion?
No.
And I have nothing further, and the record should reflect that the vote on the motion is based on the comments by Mr. Deek, Mr. Stewart, and myself. Madam Clerk?
Mr. Guccione?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
And the record should reflect that the motion fails by a vote of 3 nays and 0 yeas. Next preliminary matter. There is an allegation by the appellant that there is a violation of AMC 2107-060D3D, which provides that larger developments must provide vehicular access from project to at least 4 public streets. And in order to bring this motion to the floor, I will entertain a motion that the planning board decision in case S12599 violates AMC 2107-060D3D in that the project does not provide vehicular access to at least 4 public streets. Mr. Stewart, are you prepared to?
So moved.
Has been moved. I will second that. All right, it has has been moved by Mr. Stewart, seconded by myself, that the planning board decision in case S-12-599 violated AMC 2107-060 D3D, in that the project at hand does not provide vehicular access to at least 4 public streets. Mr. Stewart.
I think the best way to approach this is look at what the code requires, and they were talking about 4 streets being required based where it's reasonably due to topography or natural features, and that code provision that he also relies on was addressed in S-12420, and that's at pages R-384 and R-385 in the staff analysis of S-12420, and address the feasibility. But in this case, I think the vehicle access issue should have been raised and should have been filed when the decision was made on S-12420. So I think in this case, the appellant actually waived that issue when he failed to make an appeal of S-12420, and I don't think it's appropriate for him to bring it in front of this board, or at least we can't consider it, because I think the appellant's waived his opportunity to make that appeal.
And in terms of the motion, what does that mean? How do you intend to vote on the motion?
I'm not going to approve the motion because he's already waived his right to bring that up, and we should not be considering it.
Okay. Thank you, Mr. Stewart. I seconded the motion. First of all, Mr. Stewart, I think you misspoke in terms of the case number that was before the planning board when they considered this case before. It is S-12420. Isn't that correct, Mr.
Yes.
Oh, I forgot the dash.
Yes.
Okay, all right. No, it is S-12420. Did you give a different number?
Did I give a different number?
Yes, you did. So anyway, the record should reflect that the case was previously considered in S-12420. And I must tell you that I too intend to vote against the motion, and it is for this reason. What the particular case that is on appeal now, and it is S-12599, is simply an amendment to a previously approved preliminary plat. And the amendments in this particular case do not address the access to 4 streets or anything else. Those are items that should have been addressed by the appellants or by anyone else in the previously cited case, S-12420. In other words, we are simply looking at a case right now that very narrowly provides for certain amendments to S-12420. And the matter of access to 4 roads was not addressed directly by anyone, including the appellants. And so really what they should have done is they should have appealed. If they assert that there is a violation of this particular issue of 2111-302C, they should have brought that up in the previous case of 12420. but they didn't do that. So my view of the matter is that the appellants waived the right to object to it on that the decision by the plotting board in S12599 is invalid because it violates that particular provision. That is made too late. They should have made it earlier. And they, by having not made it in the earlier case, they have waived the right to bring it now. And it is for that reason that I intend to vote against the motion. Mr. Deek.
Yes, Mr. Chair, I do have some comments on this one, and again, this is specific to the amendment, i.e., the appellant is appealing the amended case. The original case, which is the S12420 case, has gone through its process of reviews, and the actual quoted section of the Title 21, which is it's titled Vehicular Access to Public Streets, has been part of that review. Now, the amendment is an amendment which requires, or requests, I guess, to remove the phasing plan and address that issue with other ways of adhering to conditions. I do think that that's a change condition from where the original case was, but in my view, the statement in the code which says unless the decision-making body determines otherwise, it's a very open statement. The decision-making body is the planning board. Unless they determine otherwise, these subsequent statements in the code would have to be adhered to. Well, it seems to me that S12420, right or wrong, adhered to the code and decided the way they decided. And now the amendment is where this issue comes up in the appeal. So it is truly a procedural matter, but I would emphasize again, the overall big picture process is something which I would like the municipality to take to heart, because it opens the issue up to this conflict between narrow view of appeals and the broad view of cases, which are actually, again, physical constructs with physical amenities. Having said that, I think this is a procedural issue which I do not think is supported by the code to be supported by us. So my intent is to not support the motion, but I wanted to make sure that the record shows that that issue of the phasing becoming a separate or a different condition.
Thank you, Mr. Deek. I take it that you intend to vote no on.
Correct that. I intend to do that.
I was the one who seconded. Oh, Mr. Stewart, you made the motion. Any further comments regarding the motion?
No, I realize that Mr. Diak has some concerns about the general process, but I don't think we're going to cure those process issues, because it deals with how the code is written, and that is something that we are not going to have any impact or should be looking at trying to change. That's going to have to be changed by some other body.
Thank you, Mr. Stewart. I must tell you, I'm very sensitive to the comments that were made by Mr. Deek, and I do agree that there is do we want to say systemic problem here that we cannot address, but that perhaps the planning board or the planning department should take a look at. So I'm very sensitive to the comments that have been made by Mr. Deek, and I would hope that both the planning board and the planning department, if they get a chance to review what we have been discussing here today, and I hope they do, that they take that to heart and see if there need to be some structural changes made. But considering the way things are right now, I must tell you, I have to vote no on this motion. I do not see any way that we can support that motion. Any further comments? Mr. Wheeler, do you have words of wisdom for us here regarding this matter?
No, sir.
Okay. Seeing no further comments, the record should reflect that the motion is made and supported or not by the comments of Mr. Stewart, myself, and Mr. Deek. Madam Clerk.
Mr. Chair, can I get clarification on the number of the planning board decision that's part of your motion, the planning board
The
decision?
previous case, yes, S-12420.
14240.
12420. I know it's confusing.
Thank you.
All right.
Mr. Kuchel?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
And the record should reflect that the motion fails by a vote of 3 yes and by a vote of 3 nays and 0 yes. We then come to the next preliminary issue and that there is an allegation by the appellant regarding violation of AMC 2107-060 D3D, which provides that larger developments. Nope, I'm wrong. Didn't I? Help me out.
Going to the next one.
Cul-de-sac.
Cul-de-sac.
5.
Okay, you are correct. It's the cul-de-sac issue that we need to address. And S12420 granted a variance from the provisions of AMC 2108-030F6A and 2103-240GB3 and allowed a longer cul-de-sac than what the ordinance originally requires. So the allegation in this case is the appellant states or contends that the planning board violated the decision regarding the cul-de-sac variance on the basis of the 2 code section that I previously stated. I will entertain a motion that the planning board decision regarding the cul-de-sac variance violated AMC 2108-030F6A and 2103-240GB3.
I will make that motion.
Thank you.
Mr. Chairman?
Hang on 1 second. I need to make notes here so that I don't get fouled up. Cul-de-sac. Yes, Mr. Wheeler.
You may have referred to 2103-240G3B as GB3. We just need to make sure we flip the end letters numbers correctly. So I think the proper reference is G3B.
Correct.
G3B as opposed to GB3.
Correct.
Thank you for correcting me. Oh, it is so good to have eagle eyes here to look over my shoulders. Mr. Stewart, are you going to second this motion,
Yes, I'll
or am
second.
I going to second it?
I'll second
Okay. Mr. Deek.
Yes. An issue is whether this variance for cul-de-sacs is, well, we say it's an motion, but this is something we need to address at this particular appeal, at this particular case. And again, this is very similar to the previous instance where a procedural issue is at hand, I believe. I do believe that the code references are proper and they are addressing the cul-de-sac length issue, which is actually fairly common in hillside development. It happens oftentimes when this variance is sought. It was granted under the previous case, which is S12420, and it was not altered in the amendment. Therefore, I do not believe that this is the proper place to address this issue as a violation of the code, and I do not intend to support it for those reasons. However, I would want to say again that the issue of variances are strictly codified, and the planning board acts based on those code requirements to make judgments on them. And this variance, although it has not changed from the original case to the amendment, does raise the question of what the jurisdiction of the planning board is, and what the process of their review is, and what support they get from the various agencies, which then allow them to make proper decisions. That is not material to this particular issue at hand, so I do not intend to support the motion. But just as we discussed it previously, and I said I will repeat this several times, this is an issue of how we deal with land development, and I think it's in the best interest of the municipality that you have happy developers and happy neighbors in an orderly development of land, and that would be my ultimate goal, not to date them.
And so you intend to vote against the motion?
Correct.
All right. Thank you, Mr. D. Mr. Stewart?
Well, this again is a situation where the appellant should have weighed or should have brought this motion up at the prior hearing, not this current hearing. And I think by failing to raise the motion on in the hearing for S12420, that his attempt to raise it now is untimely, and it's not something that we should be considering. I want to vote against the motion.
Thank you, Mr. Stewart. I have a couple comments about this. First of all, totally beside the point is the word cul-de-sac. When I was a college kid, I worked in road construction in Juneau, and we worked on a cul-de-sac. And being a first-generation immigrant, I had no idea what a cul-de-sac was. So I learned in the meantime, and I'm now fully aware of what a cul-de-sac is. So having said that, the cul-de-sac variance was granted in case S12420, and it was left undisturbed by the present case that we are considering. The appellant's argument is, since the present case, that it was based on, that the granting of the variance was based on the phase development required by S12420. And since the present case eliminated the phase development, the variance should have been voided or was voided by implication. I do not agree, and that contention by the appellant is stated in the record on page R-021, I believe, or is it 020? Either one of those two. Anyway, in my analysis, first of all, I agree that this matter should have been raised in S12420 and wasn't raised by way of appeal by either the appellants or anybody else. And the current case left that matter undisturbed. But my ultimate reason for voting against this is that I do not agree that the argument by the appellant is well taken. And that is, that when you look at the record for granting the variance in case 12420, the predominant reason that you are left with after you read the discussion by staff, by the board members, is that it was granted to accommodate natural features of the property. And that's what moved them to grant the variance. And so it is for that reason that I do not think that the argument is well taken at this point. The current case does not change the configuration of the subdivision. It does not change, it doesn't do away with physical features, it can, but, and it is for that reason that really the variance was properly granted. That's where I come down on this. And it is for that reason that I intend to vote against the motion. Any further comments by Mr. Deacon? Was your motion? Any further comments?
No, no further.
All right, Mr. Stewart.
I think there's a number of different issues that are cropping up, and they're being significantly good arguments on both sides, because the hillside area is being developed in areas where it's very steep, and the slopes and the topography create a lot of problems, and how they are dealt with become very sensitive community issues. So I think a lot of these things are going to continue to be seen, and it's hard to come out where you say, well, you've got the best balance on how the development should be in fact developed. So I think we're going to see more of these, because that's the only place left in the city for development.
Does that change your intended vote?
No, but I'm just pointing out that these issues become very contentious, and we're doing our best to look at what's in the record and make a fair decision. And it may not necessarily be agreeable to people that are involved with this case or other cases like it, but it's going to be contentious wherever the development is on the hillside, and that's the way I see it.
Thank you, Mr. Stewart. I have nothing further to add. Before we vote, the record should reflect that the vote is based on the comments of Mr. Deek, Mr. Stewart, and myself. Madam Clerk.
Mr. Judicial?
Nope.
Mr. Dean?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 0 yeas and 3 nays. So those are my preliminary issues that I wish to address. It is my intention that if there are no further preliminary issues before we get into the meat of the appeal itself, that we take a 5 or 10 minute break. So first of all, are there any further preliminary issues that we need to address today? Mr. Deek, do you have anything else?
It felt like meat to me already, so I'm looking forward to meat.
Okay, Mr. Stewart.
No.
What does our watchdog say here? Mr. Wheeler, are there any preliminary issues that we have not addressed that we should address at this point before we take a break and then get into the substantive issues?
Mr. Chairman, I would like to raise one question, and maybe it's something the members can sort of individually contemplate in their break time if they want to. But looking back at what we've done, we have excluded certain exhibits filed by the appellant. Does that mean we've also disposed of the issues raised by the appellant in their notice of appeal and in their reply? For example, the allegation regarding Spinelli's authority to file the application. We've resolved that the exhibits are not submitted, but we haven't necessarily resolved the underlying argument, which is now effectively unsupported by exhibits. So it might be appropriate to go back and revisit those 3 areas of argument raised by some of those exhibits. That is Spinelli's authority to file. I've got to find the other 2, but we think about that. We may want to just touch on those because it may be appropriate to resolve them since they were raised as arguments.
My way of thinking, and I stand to be corrected on this, is that once we have addressed the substantive issues on appeal, and perhaps this is a substantive issue, I'm not saying it is not important to consider whether Spinelli had the authority to file this at all, is that we look at a catch-all motion to address the remaining issues, if there are any. Maybe that's the way to handle that. Because I think this is a matter of substance and not of procedure itself. Does that make sense?
Mr. Chairman, as long as the board touches on them either now or later, I'm happy.
Okay.
Mr.
Mr. D.
Yeah, I think this is. Thank you for bringing it up because the appellant has specific allegations, and one of them being the procedural issue of the representation by. I guess Spinelli is the company in this case, but Spinelli representing the entirety of this subdivision as the petitioner. That was basically the basis of that I guess issue raised by the appellant. Then the conflict of interest issues, and I think the third one was about the jurisdiction. So I think there may be maybe a need to discuss whether the specifics are addressed now as a preliminary matter, or as you say, in a matter after we have concluded the issues, because somewhere we're probably going to have to speak to that, and I would like to make sure that we do that. And as Mr. Wheeler mentioned, that if we exclude the evidence, then what is the mechanism to do that? And I'm probably the least prepared of all of us here to know how to do this. I'm not the legal expert, but I think we should definitely make sure that these things will get covered.
Before I turn to Mr. Stewart on this, there were three areas that you raised. The first one is the authority of Mr. Spinelli.
Yes.
The second one is the conflict of interest.
Yes.
By board members. And what was the third?
Mr. Chairman, at least with respect to addressing the grouping of exhibits, I had said the third area of the exhibits dealt with municipal documents or web pages regarding secondary access. Obviously you're going to get into the discussion of secondary access in the body of your deliberations today, so that one will probably take care of itself, right, during the course of that conversation. The other two we might miss. I think I discussed conflicts issue in the body of the appeal issue
Yes.
as well. So it gets I touch on it twice there. So that one also may come up again. So we just need to make sure we cover the allegation regarding Spinelli's authority appropriately before we end deliberations.
My druthers would be that is an issue on appeal that needs to be addressed not as a preliminary matter, but as a substantive matter. And so that we simply add that as an issue on appeal once we have gone through the other issues that are obvious and apparent. Does that make sense?
Yes, sir.
Mr. Deek, does that make sense? Mr. Stewart?
Yes. Have we gone through this to make sure that there aren't other issues that we need to add to that list?
Mr. Weaver?
Mr. Chairman, my intention is to do my best to make sure we get through everything and check it all off as we go. So ask me that question again as we get to the end.
Okay, I just
we may
wanted to
even
make
pause
sure
for a
that
few minutes.
somebody was watching that and
Yes,
and
I
writing them
do
down as we
agree.
go
There
through.
are so many issues here that it's easy to overlook some. Yes. So when we are through with the substantive issues on appeal, and that includes the authority of Mr. Spinelli, and we will need to have some help on that we pause for a few minutes and give Mr. Wheeler time to reflect on whether we have covered all bases of the appeal. Okay?
Sounds good, sir.
Does that make sense?
Yes.
All right. So having said that, why don't we take a 10-minute break? Go off the record for 10 minutes. The appeal of Planning Board case number S-12599. Before we proceed to further motions, I want to make the following statement just for the record here. We have so far considered what was deemed to be preliminary matters, and we are now heading to a group of items that are really the meat and substance of the appeal itself. By way of having labeled certain items preliminary versus substantive, I did not, and I don't think any member of this board intends to belittle in any way the appeal effort by the appellants. It is simply that we labeled certain matters, and it is for that reason only. It does not remove or reduce the importance of the preliminary matters that we ruled on from the appeal itself. So, having said that, we then turn to certain other matters, and the first one is that there is an allegation by the appellant that the Planning Board's approval of the requested modifications to the preliminary plat approved in S-12420 as contained in this case violates AMC 2101 030 B, G, K, and L. And by way of bringing this matter to the floor, I will entertain a motion that the approval granted by the Planning Board in this case S-12599 violates the provisions of AMC 2101.030 B, G, K, and L. And before I ask for somebody to make that motion, I need to turn to our esteemed lawyer and ask him if I stated this correctly.
You did.
Thank you so much. And so with that then, I will entertain a motion that I have stated, and Mr. Deek will make that motion. And Mr. Stewart, are you prepared to second this or not?
Yes, a second.
Okay, thank you. And Mr. Deek, would you address the motion, please?
Yes, Mr. Chair. This motion addresses the issue of violating the general conditions of the land use code, specific sections B, G, K, and L. The general sections of the land use code are setting the intent for how the land use regulations are supporting development in Anchorage. The specific approvals for projects are weighed against those general intent conditions. And the planning board's task is to go into the specifics for each development and address the overall intent by approving projects or not approving projects based on the specific conditions of those projects. In this particular instance, I do not believe that the planning board acted in a manner that violated the general conditions of the code. Item B is about quality housing, supply of quality housing. Item G, it's about protecting development and protecting development and the residents of the municipality from natural hazards. K is a pattern of promoting a pattern of land use, which provide adequate support for that land use. And then L is the one which is developing transportation patterns which develop the public health and welfare and safety. Now, in reviewing the record and reviewing the materials in front of us, I do not believe that the planning board violated any of these conditions by reviewing with support from various agencies to make determinations whether the project in specifics adheres to these general conditions. And it is certainly always a subjective, I think, matter to address the extent of how well or how badly, I guess, these conditions are stated to adhere to the general intent. But I do believe that that the planning board took the case, reviewed it on its merit, and addressed all of these issues. And again, B is about providing quality housing. I don't think that there's any violation here regarding this issue. G, about the issues of natural hazards. The substantial time and effort was taken in this case to address those. One of them specifically was fire safety. K is a pattern of land use. In this case, the pattern of land use on the record appears to be showing up in the maps supplied in the record, which are similar or consistent with what the surrounding land use is. And then the transportation development patterns was also an issue here regarding access and the number of access points. There's substantially discussed in the record about that issue being determined by the planning board. So in that sense, I do not believe that this motion is one I can support.
Thank you, Mr. D. Mr. Stewart.
Yeah, this is another case where there's not good alternatives, or maybe alternatives are viewed in different ways of handling the development. But I think one thing that you see throughout this in B, G, K, and L is you're looking at safety and you're looking at hazards. And I think those three items have been addressed. The appellee addresses these in detail in pages 4 to 8 of their brief. And the appellant has covered this in the record at record-007 through record-0112. And, there's reasons for arguments on both sides, but I think when you look at the pros and cons, there's some disagreement as to whether or not the water system is a good alternative to the the phasing construction and the sprinkler systems. And I think there was one other one. But we're looking at primarily, I guess it's going to be safety issues and how they impact on each of those provisions cited. Well, the other one was, I think, the impact of on the Firewise construction. And in this case, there's funding for the extension to mountain air design. I think that builds into and provides some background for some of the arguments. But the AFD, the fire department, their position is the water system offsets the sprinklers Firewise system because they're giving priority to the water availability on the hillside to fight wildfires and to respond to other emergencies. And they prioritize that over the secondary access. The planning board, I think, evaluated the evidence, very in much detail, and they found that the fire system outweighed safety of the phased construction with the access road. And they also found that private development of the water system was not something that is feasible from a private development standpoint, just because it's just too expensive. And the water system, in order for that to go in, requires full development of the subdivision. And again, I think from the pros standpoint, they're increasing the fire safety for the homes, they're increasing the fire safety for the hillside area. But on the other side, you've got the development, there's an allegation that development by itself, just being added to that hillside scenario, may increase risk of wildfire, or risk due to wildfire, let me put it that way. Because there's more homes to be taken care of. You need to look at egress, ingress. You need to look at ways to fight the fires and respond to the hazards and the risks. I note that the traffic department did not support removal of the phasing, and they prefer that they have the priority that the secondary access should go in, and that's on Mountain Air Drive. I think the lack of Firewise construction would probably increase the risk for that people take living there due to wildfires, and the lack of sprinkler systems in the particular homes. Again, that's an expensive item, but it may increase the risk to homes. But on the other hand, that the private water system that they've approved and they're going to put in does have hydrants, and it makes the hydrants. I think there's 5 hydrants that are going to be in that area, and that provides that offsets the sprinkler systems, because the fire apparatus can get in there and they have quick access to the water. So in this case, it looks like there's been significant discussion on the record in whether or not these particular items were violated, and I don't think that they were in fact violated. I think if you weigh the evidence between the two, the approval by the planning board does not violate the provisions of the AMC 2101, 030, and those sections listed in the motion. So I intend to vote against this motion.
Thank you, Mr. Stewart. I likewise intend to vote against the motion, and it is for this reason. The section cited by the appellant in his notice of appeal, that is asserting violations of 2101 and 30, B, G, K, and L. Those provisions in that ordinance are really general statements that are incorporated into the approval criteria by which the planning board must decide whether to grant a preliminary plat or not, and that is contained specifically in the AMC 2103 200C9. In other words, the sections cited by the appellant, capital B, G, K, and L of 2101 030, are general statements that govern approval considerations, and that is more directly stated than in 2103 200C9. The appellant's arguments in favor of asserting that there is a violation of the ordinance stated is in R007. Spinelli makes significant arguments in his brief, in the appellant's brief at pages 4 and 5. And the planning board, really, not having had the benefit of those documents and those arguments, in any event, considered the matter and came to a finding that I want to recite here. It's at R298. With respect to public safety, the findings are that the development being put in with this fire system is in balance of safety and is a safer solution that was previously heard. In other words, S12599 is simply an amendment of what was previously approved, and that was the phased development. And here, the planning board was faced with the issue of weighing road access versus water supply. And it came to the conclusion that water is more important than access. And there are various, if you look at the record as a whole, there are various reasons to support that decision by the planning board. In other words, there is substantial evidence in the record to support the planning board's decision and to really negate any asserted violation of 2101 or 30B, G, K, and L. And it is for that reason that I intend to vote against the motion. Mr. Deek, any further comments regarding the motion?
No.
Mr. Stewart, nothing further. And I have nothing further. And having then heard the statements made in favor or against the motion, the record should reflect that the motion is based on the comments of Mr. Deek, Mr. Stewart, and myself. Madam Clerk?
Mr. Judicial?
No.
Mr. Deek?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 0 nays and 0 yeas and 3 nays. Thank you so much, and I apologize for misstating that. Now, before we go to the next one, Madam Clerk, I'm looking at the clock, and it says a few minutes past noon, and so the question is whether we should go off the record for a minute or two so that members who wish to grab lunch can do so. Is it there?
The lunch is here. Totally.
All right, so we will go off the record for a few minutes. Case 2021-2, appeal of planning board decision S12599. The second issue that I want to raise is that there is an allegation by the appellant that the decision by the planning board violates the provisions of AMCR 21-90. And there are various violations cited, are alleged that that the decision violates the provisions of that chapter. That allegation is contained in appellant's second set of errors, third set of errors, and fourth set of errors in various forms. The appellee argues that the motion does not apply at all, that the section cited does not apply at all to this case because of the wording of this section cited. So, by way of raising this issue is that I would like to, and I will simply make that motion myself, that the planning board's decision in case 12599 violates the provisions of AMCR 2190. May I have a second for that, please?
Yes, sir.
Thank Thank you, Mr. Deek. Let me address this issue. AMCR 2190-001 definitions provides that the section applies to a, quote, residential development ultimately consisting of more than 2 dwellings per lot or tract. And it is argued by the appellant that the development does violate that section. And Spinelli responds to that by saying this does not apply at all, because what you have here is 27 lots, each with 1 residential structure on it. There are no multiple dwellings on a lot, nor could there be, as the property is zoned R10, and by AMC 2105-010, multiple dwellings on a lot are not permitted in that zoning district. I must say, in looking at this on balance, I do agree with the appellee's position in this case, that AMC 2190 does not apply to this case at all, because there are, in fact, 27 lots with no multiple dwellings on a single lot. So the appellant, on the other hand, takes the position, well, what it is right now is it is 1 lot, and that's what you need to look at, and there are multiple dwellings on this 1 lot. Well, that's not the proper way of looking at it, to my way of thinking, and for that reason, I do not believe that 2190 applies to this case at all, and I intend to vote against it for that reason. Mr. Deek.
Yes, sir. 2190, most of us who are dealing with the land use code lovingly used to refer to this as the site condo ordinance. And the reason for that is because this particular DMCR it was developed in order to address multiple dwelling units on a single lot, because at that time no proper conditions existed to address development standards for those kind of conditions. So in that regard, it is clear that that the development itself in this original case, which is the 12-420, and the amended case, we are dealing with subdivision which are subdividing a larger tract into lots, individual lots. So because of that distinction, I do not believe that the record is supporting this statement by the appellant, or this I guess challenge by the appellant. And I also do believe that the issues which are raised in the EMCR 2190 perhaps are relevant in the sense that they address the number of dwelling units within the development, and there is this issue on AMCR 2190. It's F3B, I believe I coded that right, which deals with the number of buildings or units in an area which then are supported by fire access and those conditions. Although there are similarities in the intent of providing access and providing safe servicing of those units, the code simply doesn't allow us to look at AMCR 2090 as applicable to a larger tract after it has been subdivided into smaller ones. And that is the basis why I do not think that this challenge, this appeal is appropriate to support, and I do not support it.
Thank you, Mr. Deek. Mr. Stewart?
Well, I note that AMC was 05.010 allows only residential use of property as a dwelling, single family, and detached. And that definition is set forth, what is meant by that is set forth in 2105.030. And it defines that situation as one detached building on its own lot, designated for one household with a complete living facilities and constitutes one dwelling unit. So by that definition and the information that was quoted by the chair, I think it's pretty clear that AMC R 21-90 does not apply to this because it's restricted clearly to single dwelling units per lot.
And so how do you intend to vote on the motion, Mr. Stewart?
I intend to vote against the motion.
Thank you, Mr. Stewart. I have no further comments regarding, in addition to the comments I previously made, and I would incorporate the comments made by Mr. Deek and Mr. Stewart. Anything further regarding the motion? Any further argument, discussion? Mr. Deek?
Just one, Mr. Chair, and that is that the subdivision regulations do describe conditions and they do prescribe a manner in which subdivisions are developed. They are specific to a multitude of issues, from road access, transportation issues, safety, fire, and all that. That is in the code already. AMCR 2190 was developed to address the similar issues on a singular lot. So I do think that the planning board acted accurately by making the decisions as it's shown on the record. And I do not believe, as I mentioned, that this approval violates the AMCR 2190. So I will vote against it, as I said.
Thank you, Mr. Deek. Any further comments, Mr. Stewart?
Based on what Mr. Diak said, I would note that the definition of that attached unit, dwelling, it specifically states in there that it's applicable only to AMCR 21.90. That is not to be used for the general, so that supports your contention that we're looking at a separate situation here, just with single units.
Okay. I have no further comments. If we are ready to vote on this matter, the vote will reflect the statements and arguments made by myself, Mr. Deek, and Mr. Stewart. Madam Clerk?
Mr. Buchel?
No.
Mr. Deek?
No?
Mr. Stewart?
No.
And the motion fails by a vote of 0 yes and 3 nays. We then come to the next issue, and that is that the appellant argues that the approval violates AMC 2345.D107.1. As was pointed out, that there is a mistaken citation here, that there is no such subsection, that what in fact D1071 refers to is an attachment, I believe, of the fire code. Isn't that correct, Mr. Wheeler?
Yes, sir, it's an appendix to the fire code.
Okay, all right. So, really what we are talking about is, and what the appellant really is saying is that the decision and S 12599 violates the provisions of AMC 2345, which provides in Appendix D that 2 access roads are required where the number of dwelling units exceeds 30. So in order to bring this matter to the floor, I will entertain a motion that, as I said, the motion should be that the decision in S 12599 violates the provisions of AMC 2345, which provides in Appendix D that 2 access roads are required where the number of dwelling units exceeds 30. Has been moved by Mr. Stewart and seconded by Mr. Deek. All right, Mr. Stewart.
I might note right up front that I'm going to vote against this motion. But I do note that the decision is in the authority goes to the fire code official under that section that you quoted, and they're charged with administration and enforcement of the code. And that decision, I think it boils down to whether the definition of whether I think it's whether that decision by the fire official or the fire code official is in fact something that is that requires agency expertise, or whether it's something that we can address and look at whether or not there's special requirements as to whether we should override we should vote in favor of this motion. And that goes back, and I think it goes back to the exceptions when you talked about the decision that if you exceed 30 units, then in a development that you have to have 2 or more separate approved access roads. That decision has an exception, or that code has an exception. The number of dwelling units shall not be increased unless the fire code official determines fire apparatus access roads will connect to that particular development. And in this case, I think that's what they're challenging. In this case, I would say that fire department official is designated by code. They're not officially delegated, or it doesn't state specifically in the code that they had agency expertise to do this. But on the other hand, for the assembly approving this fire code provision, I don't think they would have designated the fire official in fire department to make these decisions. I think there's a implication that this has a agency expertise in the fire department that they were looking at when they gave this responsibility to the fire code official to make that decision. I look at this in terms of also whether or not well, I guess I don't think this is something where we should be taking over to try to make a decision in lieu of or overturn the fire department's official determination that they're saying was violated. So I think it's not within our, I don't think it's prudent for us to override that decision, so I'm going to vote against this motion.
Thank you, Mr. Stewart. Mr. Deek?
Yes, the motion is about, the motion states that the approval of the case, and I'm gonna probably quote the number, the amendment case, is violating the municipal Title 23. That is the basic motion. I do not believe that there is evidence that is actually true, and I do not believe that for that reason I will not support the motion. So the background of that is that the Municipal Assembly adopts the updated international codes with local amendments. It's a standard procedure, long-standing standard procedure. It is not explicit in the record, but it's implied in the record because that's how we do development. Now, the fire code reference here about the particular number of units is a relevant case because exactly why IFC addresses the number of units for fire safety reasons. The amendment sought the removal of the phasing and offered a condition which would address fire issues by implementing a local water system which will provide both water for the units, which are probably going to be 27, since there are 27 lots. That's the most of them you can have on this development as proposed, and also allow enough volume to create a fire hydrant system which then can support fire suppression. That condition tells me that adequate review was taken by the reviewing agencies, including the fire department, to make sure that this condition is adequate to further the goals of the not just the land use code but also Title 23 for implementing the International Fire Code, and that is, I think, the basis why I can not support the motion. I do think that it got review. I don't think there's anything in the record which negates that they were that they are violating the code. It is certainly arguable whether anyone agrees whether they have done the job in a manner that they consider adequate. I think that's not our purview to the adequacy of the decision in terms of its complexity is not our purview to decide. I think the record does not support any of the motion's basic statement, which it is saying that it violates Title 23. I do not believe I can support that.
Thank you, Mr. Stewart. I want to add my 5 cents worth. 2305-010 incorporates by reference the International Fire Code, including Appendix D, which provides something that is relevant here at D107.1. And that is what the appellant contends is a violation here. Now, when we look at D107.1, it provides initially that one or two family dwelling residential developments where the number of dwelling units exceeds 30 shall be provided with 2 separate and approved fire apparatus access roads. And then it talks about 2 exceptions. One, where there are more than 30 dwelling units on a single public or private fire apparatus access roads, and all dwelling units are equipped throughout with an approved automatic sprinkler system in accordance with section so and so and so and so, access from 2 directions shall not be required. And that was the basis for the decision in S12420 to require fire hydrants and sprinklers and fire safe construction, etc., etc. So that's why they said you don't need the second road as long as you have a sprinkler system and in accordance with certain sections. And so that's what was approved at that time. Now the amendment that we are dealing with says, well, why can't we look to exception number 2? And exception number 2 reads, the number of dwelling units on a single fire apparatus access road shall not be increased unless fire apparatus access roads will connect with future development as determined by the fire code official. Now, the applicant, Spinelli Homes, argues that that's really what's going on here because Mountain Air Extension will connect and will provide the secondary road access somewhere down the road. So why don't you eliminate the phasing requirement that was established by 12.420 and the sprinkler requirements because the road will be constructed. And just to make sure that in the interim we have a safe development here, we will provide a water system with 6 or 7 or 5, whatever the number is, hydrants that provide water to the 27 units in this subdivision, and also will enable the fire department to access the fire hydrants in other areas, in surrounding areas. So we are really making things a whole lot safer. And so then the planning board was confronted with this issue. Do we still require 2 access roads, or do we simply say the access road will be built sometime in the future? We don't know exactly when, but it will be built. And in the meantime, you have offered to construct a water system that is really beneficial not only to this development but also to the surrounding area. And the planning board, in weighing those 2 issues, came to the conclusion, just as the staff analysis did, that in weighing those 2 concepts, access to roads versus sprinkler system and road construction in the future, what is better, what is more beneficial, and what is safer for the people who are living here? And they came to the conclusion that water was more important than access. And so that's why the planning board agreed that exception number 2 of D107.1, the International Fire Code appendix, applied in this case. And it seems to me that we should not be second-guessing the planning board here, since there was significant evidence there to support the planning board's decision, and it is clear from the record that the planning board weighed those 2 issues and agreed that exception 2 was more applicable to the situation as applied for in 12.599 than what had previously been approved under S12420. And so I do not find that there is a violation, that in fact the exception number 2 applies in this case. It was properly applied by the planning board, and there is no violation as alleged by the appellant. And it is for that reason that I intend to vote against the motion. All right, now, having said all this, Mr. Stewart, you made the motion. Is there anything else you wish to add at this point?
Does this motion also take care of any issues that may be lingering on the phased, dropping the phased approach?
I'm not sure I understand what you're talking about. The present case, 12.599, asked to do away with a phased development required by the previous case. And remember, the phased development was required by the planning board in that case, as I understand it, and maybe somebody can correct me if I'm wrong, the phasing requirement was established because there was only one access road. And it is for that reason that the planning board then said, well, if that's the case, if there's only one access road, you need to have a phased development until there are more roads being built. So in this case, there was a different, the appellee said, why don't we look at it differently? We will provide an extra layer of safety, and so you can safely do away with that phased development. And so I believe that by approving S12599, they automatically did away with the phased requirement. And in fact, that's what the whole case is all about. Do away with a phased requirement and the sprinkler system and the Firewise construction. In lieu thereof, we are offering the following, and in addition to that, mountain air extension will be built. Now, there's an argument over what will means. Does it mean it will be constructed tomorrow or in the near future? Nobody knows. And there's plenty in the record that shows that nobody really knows what the answer is to that question, what will really means. What they are all agreeing on is that it's on the AMAT's plan, and that planning for that construction was approved, but nothing further. Funding apparently was cut off for the actual construction. So, to my way of thinking, by weighing the two issues, they automatically did away with the phased construction. And I don't think we need to address that issue.
Okay, so I think that from what you said, my concern there is going to be taken care of by this particular issue.
I think so. Mr. Wheeler, am I wrong?
No, sir, you're not wrong. I just want to make sure I understand Mr. Stewart's concern.
If there's any lingering issue that we need to look at resulting on that dropping the phased construction. After what you just said, I don't believe that there is.
Not relative to this particular code section. So, you'll have a couple more issues to work through before you resolve the case in its entirety, and whether any phasing elements part of that will be up to your deliberations. But I believe with respect to this code section,
Okay.
there's no lingering phasing issue depending on your decision.
Okay.
Anything further,
No.
Mr. D?
Yeah, I would like to just comment that the particular issue of the IFC is based. Well, there is an appellant who contends that approval of the amended case does violate the fire code. Well, the amended case is about removal of the phasing. It's inherent into that case. The phasing requirement is in the original case, and the amended case, which is under appeal today, is about the removal of the phasing and coming up with other solutions, which then justifies that request. And this particular issue here is about the justification related to the fire code. And I want to make sure that that is part of our discussions, so Mr. Stewart can perhaps make a comment on the issue of phasing. I do believe because of the phasing is what the amendment was seeking, or the removal of phasing is what the amendment was seeking, and offering mechanisms in which that could be supported by the planning board. They presented the evidence. The planning board weighed the evidence. They had a substantial discussion about that evidence, and they chose to act on that evidence based on how the approval was stated, and it's in the record. That, I think, is not a violation of the fire code as it's stated here, and that's why, as I mentioned, I do not support this particular motion.
Okay. Thank you, Mr. Deek. I have no further comments to make. If there's nothing further by board members, the decision is based on the comments by Mr. Stewart, who made the motion, by Mr. Deek, who seconded it, and by myself. Madam Clerk?
Mr. Judicial?
Nope.
Mr. Deep?
No.
Mr. Stewart?
No.
Hang on. And the motion fails by a vote of 3 nays and 0 yeas. And I think we need to get off the record for a moment to enable our esteemed counsel to go elsewhere for a second. Case number 2021-2. The next item I wish to address is the alleged approval, or it is alleged by the appellant that the approval of the application by the planning board violates AMCR 2111-304A, which in general terms provides that every decision made by the planning board must be based on and include findings of fact and conclusions. And so in order to raise this matter, I will move that the findings of the planning board in case S-12599 do not meet the requirements of AMCR 21.11.304 as alleged by the appellant in notice of appeal on R-032. May I have a second, please?
Second.
Moved by okay. As I said, the appellant argues that the notice of appeal does not satisfy the requirements that the of AMCR 2111.304, and that the decision by the planning board is not supported by evidence and is not reasonably sufficiently understood by members affected by persons affected by it. To my way of thinking, that is not the case at all. If you look at the case as a whole, in terms of all the evidence that was before the planning board, and there was plenty of it. There were the staff recommendations, the staff analysis, the various presentations by the applicant, both initially and by way of rebuttal. And then you come to the findings by the planning board, and they are found at R-297 and 298. You will find that the decision is amply supported and was supported and stated to be supported by the planning board on the basis of various factors. And they list 10 items on pages R-297 and 298 that govern their findings in this case. And in fact, it starts at 296. So, to my way of thinking, the decision is amply supported when, as we are required to look at the record, the basis of what is in the record, you come away with the distinct impression that here was initially, in case 12-420, a decision that was made to impose certain requirements on the development of this subdivision that were, frankly, onerous to the applicant And so the applicant looked around for alternatives and came up with what it thought was an acceptable alternative. And it presented that, and that is what case 12-599 is. And the planning board looked at that, considered it, and the one statement, remember what the applicant basically objected to was the phase development. That's what was the problem as far as the applicant was concerned, because they don't know and didn't know when the secondary access road would be built. And so they were faced with the issue, we can only develop, 11 lots initially until the road is built. And so they were not in favor. They were looking for alternatives, and they came up with the alternatives. And that is what 12-599 is all about. And the one statement that I will not forget ever in thinking about this case again is that the planning board members eventually said, what it comes down to is a weighing of the importance of access versus the importance of providing water. That's really what it boils down to. And we believe, and we are satisfied, we the planning board are satisfied that water in this case is more important than access. And that's what the decision turned on. And I believe that that decision by the planning board is amply supported in the record. And so I do intend to vote against the motion. Now, Mr. Deep, you seconded?
Yes, I did. So the motion is about whether the approval violates the requirement in MRC, which is about providing ample evidence to support a decision with findings of fact. The issue of substantial is I think relevant because these decisions are obviously based on information which is developed for the purpose of making the decision. Our role at this case is to weigh whether it was substantially supporting the decision the planning board made. We are not at task to decide whether we would make the same decision. And I want to make that distinction because we are not the planning board in this case. We are the Board of Adjustment, which looks at the record whether the appellant's case in terms of the approval violating AMRC 2111-034 is accurate or not in our view. And looking at the record and looking at the evidence, and as Mr. Kucha stated, the pages R296 through R298 list the findings of this case, and it definitely from 8 through N there are findings listed for this case. So to me, that's a substantial justification of the planning board's thinking. Now, the issue whether the interpretation is acceptable for everybody who would look at the same set of data and want to make a conclusion in this case is where I feel that the applicant is, or the appellant is looking at to contest here and to contest the approval in this case. But again, it's not our purview to think for the planning board. Our purview is to make sure that the record supports that decision. And I think based on what's in the record, I do see that they made the decision based on evidence. They made findings. They listed them in the findings of fact, and it's in the record. And I would not support the motion, which states that it is otherwise. So I will not support the motion.
Thank you, Mr. Deep. Mr. Stewart.
Yeah, I think this boils down to how much evidence there is. Is there substantial evidence to support what happened? And is there substantial evidence to support our understanding for the reasons of the decision? And I think there's significant evidence and there's substantial evidence in there we know exactly what the reasoning was, and we know what supported the board's findings, so I'm going to vote against this motion.
Thank you, Mr. Stewart. The only thing I wish to add is that when you look at the transcript, Mr. Cross and Chair Walker addressed this issue at length, the evidence and what the decision of the board is based on. And I'm looking at the transcript at pages 49 and 50 for Mr. Cross, and at pages 51 and 52 for Mr. Walker. And it is clear that they carefully considered the evidence, and I think the record supports that. And it is for that reason that I intend to vote against the motion. Having said that, is there any additional comment, or can we vote on the matter? Mr. Deek, anything further?
No, I'm glad that you brought up the transcript. I think Mr. Walker specifically talks about this issue in the transcript, about the choice you mentioned about the access versus availability of water for fire suppression. So I think that part of the record shows evidence on which the decision was made.
Okay. Mr. Stewart, anything further?
No.
I have nothing further. We are prepared to vote, and the decision is based on the statements made by myself, by Mr. Deek, and Mr. Stewart. Madam Clerk.
Thank you, Mr. Chair. Just to confirm, the motion states that the findings of the planning board in this case does not meet the requirements. Is that correct?
No, meet the requirements.
Okay. All right.
Meet the requirements.
Thank you for clarifying.
Yes? Just 1 second. Yes? Give me a second, Ken. I stand corrected. The motion read, Madam Clerk, the findings of the planning board in case S-12599 do not meet the requirements of AMCR 21.11.304. That's what we are voting on, and
Thank you. Mr. Gujal?
no,
Mr. Deep?
No.
Mr. Stewart?
No.
and the motion fails by a vote of 0 yeas and 3 nays. We then come to the next matter, to the next item, and that is the thorny concept that the appellant asserts at R040 to R043 that the decision violates the appellant's due process or equal protection rights. And this is a complex matter that we need to address in phases. So the first one that I have looked at and that I think we can safely address is because the appellant makes the argument that the decision adversely affects his interests, including risk to his life, risk of wildfire, and the ability to sell the home, that we make a motion that the decision in S-12599 violates the appellant's rights because it affects his interests and is therefore void for constitutional reasons. May I have somebody to make that motion, please? Mr. Stewart, are you prepared to make that motion?
Would you reread that?
Yes, I will. I'll be happy to. The decision in S-12599 violates the appellant's rights because it affects his interests and is therefore void for constitutional reasons.
So moved.
Thank you. Mr. Deek?
Sure, second.
Mr. Stewart?
Well, this looks like another way to try to approach what he's been, I think, arguing in the prior case and in this one before us. His interests, I think that, well, the adverse effect is he may have to utilize his existing access rights. And the record does reflect that he has legal access through two different places, Fairview Place and West Circle. Although, if they pushed out Fairview, not Fairview, Mountain View. I think if they push that out, he may have some additional access. But in this case, he says he argues that he has vested property rights, and there's nothing in the record that indicates what his property rights are that are vested. And I think what he's looking at is trying to figure out a way that there's some of this development can in fact include the property that he occupies right now. And if you look at his interests, he's had plenty of opportunity to put that into the record as to how he's actually impacted and whether he has constitutional rights. He's alleged it, but he's not put anything into the record to support that allegation. And as far as I'm concerned, he failed to raise this in the prior case, and I think he's waived that opportunity to raise it in this case. So I don't think that he has good grounds to make the allegations that he's making, and I'm not going to vote in favor of that motion.
Thank you, Mr. Stewart. Mr. Dean.
Mr. Chair, let's maybe revisit the motion itself, because I believe the motion includes the statement of adversely affecting its interest, but does not include the specifics about the risk of their lives and so on. Is the intent of this motion to include those specifics, or we just in general state interest?
It was intended to state specifically that it affects his interests, including risk to his life, risk of wildfire, and the ability to sell his home.
Okay.
So that is incorporated, to my way of thinking, that is incorporated into the motion. And if Mr. Stewart agrees with that, that's the way
Yes.
the motion should read.
Okay. Well, I seconded it with that assumption as well. So let's be clear that I assume
Thank
that
you.
that's the case, but let's
Yes,
clarify.
yes.
So one of the reasons why that's important is because the record does not show, to me at least clearly, what Mr. Birnbaum's interests are. It does show that he contests his approval by appealing it and raising issues which relate to basically life safety, risk of wildfire, I guess risk of maybe to the lives by traffic and other reasons perhaps, and then economic value. Now, I do believe that those conditions would not exist, and obviously would not be raised if there would be no development on the adjacent property. The trigger for these interests being adversely affected is development. We do not have the ability to address the ability of development of this parcel. What we do have the ability to do is look at whether the planning board doing its job, did it properly and did it in a way that is consistent with the municipal code. I don't see anything in the record which tells me that that Mr. Birnbaum's interests were adversely affected in a way that was not given due consideration before making the decision by the planning board. I think the issues which are raised were inherent in development, and they were reviewed by the agencies, provided testimony during the hearing, and the planning board made their decision based on those. So they were following the procedures, and with that in mind, the idea of bringing this issue to us by basically weighing between allowing development versus not allowing development, I don't think is the proper way of addressing this issue. And with that, I will not support the motion.
Thank you, Mr. Deek. Likewise, I do not intend to support the motion. The appellant claims that the approval adversely affects his interests, that is, provides a risk to life, a risk to wildfire, inability to sell his home. But these assertions it's really speculative. No evidence has been provided, and simply just throwing it out and making that statement is not enough, particularly when you talk about an alleged violation of constitutional rights to due process and equal protection under the law. So I think the motion must fail for that reason. But it also must fail for the reason that the appellant did not appeal the prior case, 12-420. And as the current case is simply an amendment to it in a particular way, I don't think he is raising the issue at the appropriate time. He should have raised the issue by appealing S-12-420 originally. So it is for those two reasons that I do not intend to support the motion. Anything further, Mr. Stewart?
No.
Mr. Deek?
No.
And I have nothing further either, and the record should reflect that this motion is affected by the comments made by Mr. Stewart, Mr. Deek, and myself. Madam Clerk.
Yes, Mr. Chair. Can you please clarify if you intend to have the word adversely in front of the word affects in the motion?
Give me a second here. The answer is yes.
Thank you. Mr. Fuchs?
Nope.
Mr. Deek?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 0 yeas and 3 nays. We then come to the next item, and that is that private interests. Let me quickly look at my notes here. The allegation by the appellant is that planning board members have private interests in the outcome of this case and are biased. And so and that the decision reflects the bias. So I would like to propose a motion that the decision by the planning board in case S-12-599 is void because board members were biased in favor of Spinelli. And this brings up the matter, one aspect of the applicants involved. So, having made this convoluted statement, I will be the one who makes that motion.
Should I second it?
And Mr. Deek will second that.
I will do that.
Give me a second, please, so to speak. And I will speak to that motion. This is a very broad allegation, and I must tell you, those of us who have been involved in the planning process for quite a while, and all three of us board members here have. We are familiar with the concept of having to recuse ourselves when we feel there is a conflict of interest or the appearance of a conflict of interest. And in fact, both the Municipal Code of Ethics and various other provisions of the code address that. And in this particular case, the only board member who raised an issue of a potential conflict was Ms. Well, her name will come to me in a second, but there was Mrs. McGillivray, if I pronounce that correctly. She is the one who said, I know somebody here and so I should be excused. And the board quite correctly made a motion, looked at that issue and determined that she did not have an interest that precluded her from participating in the case or voting on the case, and in fact directed her to participate. So to those of us who are involved in this, we know the standards, and we feel, at least I feel, that there is no apparent conflict of interest here that is evident on the record or was disclosed inherently. We live in a reasonably small community. We all know a lot of people. We know the location of projects. Does that mean we automatically have to disqualify ourselves? No, it does not. The code specifically says, here are certain circumstances where you must excuse yourself. And none of the standards specified by the code were reached in this particular case. So there is simply no evidence, to my way of thinking, there is no evidence of private interests or bias that board members displayed that affected their decisions and requires us to void the decision in case S12599 for that reason. It is for that reason that I intend to vote against that motion. Mr. Deek.
Yes, Mr. Chair. This is another time when I would like to make some comments about the process itself. Before addressing specific issues. The assertion of bias is based on perception or real data, or real information. And the planning board itself certainly can be interpreted as a body which has an inherent bias in the process of development. It would not exist for any other reason but to have a administrative body to make sure that orderly development based on the code happens. So that in itself is an inherent bias, and I do tend to agree with that actually. Just like the appellant states, those biases exist. The issue here is whether that bias was specific to this case and is asserted in a way that it's violating the project or the process for this project and make it renders the decision questionable or nil because of that bias. The planning board did act in one case to ask a member to remain on board and participate. It does have members. It does have the requirement for the members to adhere to the ethics rules and also the procedures which are in the code to declare any kind of conflict of interest which are relevant to the specific case, and there is a description in the code of what constitutes that. The process in which the planning board asserted its, way of acting was actually proper. They did ask the members. The member declared a conflict of interest, or brought one up, the planning board weighed that and then acted based on their information on how to proceed. They chose to proceed that the conflict of interest in that particular case did not exist. And also, no other members brought up their any kind of conflict of interest for this case. So I think for the record, in our record, there is no evidence that private interests for this particular case drove the decision to validates. In that regard, I would agree with Mr. Chair that I would not be able to support the motion. On the other hand, I do want to say again that the inherent bias and the process is not the first time it came up with the planning board's history through my professional career here in town. And it's something that the planning department needs to take seriously and the administration needs to take seriously. So the perception of bias also is able to be addressed so the public doesn't feel like that the planning board acts in a biased manner. I want to put that on the record because I think that's important. With that, I still not support the motion.
Thank you, Mr. Deek. Mr. Stewart?
And I agree with both your comments, but I'd like to add that I see nothing in the record where his allegation of bias is supported by anybody on the planning board having the financial gain personally from voting on this particular issue. So I think I'm going to vote not in favor of this particular motion.
Thank you, Mr. Stewart. Any further comments? Mr. Deek, anything further?
I do not, but looks like council has.
All right. Do you have something that you wish to add?
I do, Mr. Chairman. Yes, sir, thank you. I was curious if the board would consider addressing whether or not this board even has jurisdiction to address the matter. I myself am concerned that the board may not have jurisdiction, and it might be worth discussing that issue as well for the record.
Would you elaborate on that? Why are you saying that the board does not have jurisdiction to consider that?
There may be two reasons. One, as you discussed, the planning board addresses the conflicts of interest of its members, and there's an expectation that members make those disclosures. That doesn't prevent somebody from raising the issue separately, but that issue should be presented to the planning board in the first instance. That was not done as far as I can tell in the record. Secondarily, typically complaints regarding ethics would go to the ethics board. And again, as far as I can tell from the record, there was no complaint made to the ethics board. So I have some doubt that this board can hear the matter, either because it wasn't raised at the planning board and made part of the record, or secondarily, it's just not a jurisdictional issue for the board because complaints beyond being raised to the planning board should go to the ethics board, which is what it's for.
Okay. Mr. Deek?
Yes, I do have a question about that because I actually agree with that issue, but we cannot deal with the appeal if we don't address the issue somehow. And the only way to address the issue for us is to address the specific issue with as the appellant states. So I'm not sure if you are able to give us a mechanism how to do our job and not to address this issue. But
I think what you've done so far is perfectly fine. So my structure that I'm suggesting is you note that you may not have jurisdiction for these reasons. But even if you did have jurisdiction, according to your motion, you're not finding any bias that affects the outcome.
So,
And then you're done.
so I simply wish to incorporate that statement that Mr. Wheeler made. So really the issue is, as far as I'm concerned, with regard to the motion that is on the floor at the present time, if we do have authority to voice it, to voice an opinion on this, and that is questionable, we do not see any violation by the planning board. And so I would simply leave it at that. I do agree that there is a question whether we can even address this issue, but assuming arguendo that we can, we do not find any violation. So that is my point.
So how does that change the motion?
It does not change the motion at all, as far as I'm concerned.
You just add the finding.
Yes.
Got it.
Mr. Stewart, anything further? You look doubtful.
No, I just look at it as, I think what he just said is that there's a separate structure for dealing with this particular issue that should be followed, and it hasn't been followed. So therefore, why do we have jurisdiction over this? So, what you're saying is, as long as what Dennis described there as the separate structure that's available to handle these types of issues, if that's in the record now, just because of your statement. So I'm satisfied that we've captured what we need to capture.
Okay, thank you. Does that satisfy your concerns, Mr.
sir.
Thank you. Madam Clerk?
Mr. Guchap?
Nope.
Mr. Heath?
No?
Mr. Stewart?
No.
And the motion fails by a vote of 0 yeas and 3 nays. We then come to the next allegation, and that is that that the decision, that Mr. Spinelli had an undue advantage under the code, and that the decision should be either invalidated, reversed, amended, what have you, because the decision is the result of the applicant's undue advantage. So by way of bringing this up and bringing it to the floor, I will again propose a motion that the decision in case S-12-599 is the result of the compliant's undue advantage under the code and is therefore, no, we simply leave that statement as it is, that the decision in case S-12-599 is the result of the applicant's undue advantage under the code. Leave it at that.
That's the motion.
That is the motion.
Second.
And it has been seconded. Thank you. Let me address that. The appellant's complaint really is about the code because there's nothing in the record that tells me that the applicant had any influence other than discussing the case with the planning department and the staff and the various agencies in the city. There is nothing in the record that shows me that the applicant had any unfair advantage here in this case or was surreptitiously influencing the planning board to come to the decision that it did. And so really, and this gets back to Mr. Deek's argument, there is an inherent problem perhaps with the code itself that structures applications to the planning board and to various other boards in a particular way. But to my way of thinking, that is not something that rises or to the level where we should invalidate decisions unless we see something in the record that really has provided an undue influence and undue disadvantage to the public, undue influence to the applicant, undue ability to contest anything by the public or by the appellant. Here, the Spinelli, the appellant's particular argument is that the time frame for public review is too short, that the applicant was not able to ask questions, that the appeal code is biased against the appellant, and that appeal fees should not be assessed. Well, these are all matters that are addressed by code, and so if the appellant is arguing with us over these issues, he is clearly addressing the wrong body. And it seems to me that he needs to address those parts of the municipal administration that set up the code and provide for amendments to the code, and that is basically the assembly and the administration. So the complaint here is not about the decision rendered by the planning board or a violation of code provisions. It is the process itself that the applicant is unhappy with, that the appellant is unhappy with. But it needs to be remembered that this board, the Board of Adjustment, is simply able to look at the record to determine whether violations of code provisions have occurred, not whether code provisions are in fact good or bad. So, to my way of thinking, the Board of Adjustment cannot grant any relief in this case to the appellant. He needs to bring his complaints, that the time frame for public review is too short, that he was not able to ask questions, that the appeal code is biased against him, and that the appeal fees should not be assessed. That's a matter that he needs to address to the Assembly and not to us. And it is for that reason that I intend to vote against the motion. Mr. Deek.
Yes. You touched upon, Mr. Chair, you touched upon the idea that our group here in the Board of Adjustment is not a policy-making body where most of these, actually all of these issues could be addressed. Now, it does not mean that we may have personal views in terms of even undue advantages or biases inherent in the code. As I stated before, development occurs in a way that there is an interest which drives the actual undertaking. The appellant is in a position where that trigger is where his real or perceived interests are violated. So the issue really is development. Now, we are looking at a development, a land use body which deals with development based on the rules which are set in the code, developed by policymakers. And then it brings the appellant to a point where he believes that how the system is built is favoring developers versus, I guess in this case, let's just call it neighbors, because I'm not sure what the actual construct would be in terms of Mr. Birnbaum's position. So I do not believe that we have any jurisdiction to address whether the public review is at specific and adequate length, whether the way of people being educated about the process and being able to participate is properly executed, and whether the cost of appeals and any of the processes which then allow to contest the decisions are set in favor or against the appellants. Obviously, the developers are driven by personal decisions which are structured in a way that their business includes going through these processes, while the appellant is not in the business of appealing cases. So that's an inherent conflict which is a policy issue. I do not believe we have any jurisdiction to address it. I do have some sentiment in hoping that we can further the way how we do business and eliminate appeals which are frivolous, and perhaps get to the ones which are truly based on the conditions of the particular cases. In this instance, I do not believe that we have the standing to act in favor of the motion, and I will not support it.
Thank you, Mr. Deek. Mr. Stewart.
The code also fosters development. So there's a weighing factor in here. The developers are encouraged to develop, and that's in the 2020 plan. And yet, you've also got processes that are imposed on developers and on people that are affected, maybe by the development, maybe an adjacent areas and adjacent properties. But I think in total, this is about how the code has been set up to address the process. And the process, I think, could be better handled, and I think maybe not necessarily by individual assemblymen or individual parties within the municipality, but maybe they ought to think about coming up with some sort of a task force that would bring in certain perspectives, and they conduct a review of the process and come up with recommendations that could be looked at by the municipality, rather than just saying, well, it's the municipality's responsibility. When there's a problem, maybe there needs to be a suggestion to them about that the planning might be able to do, where you could get the people that are affected to come in and actually talk about maybe there's a better way on setting up the code and setting up the process. But regardless, it's not our responsibility to take that make that decision here, because we're talking code process, and I tend to vote against it.
Thank you. Any further comments by Mr. Deek?
No.
Mr. Stewart, anything further?
No.
And I have nothing further. So we are ready to vote on the motion, Madam Clerk?
Mr. Judicial?
No.
Mr. Deep?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 0 yeas and 3 nays. That then brings us to maybe not the final aspect of this, of reviewing the appellant's arguments, and that is that the other part of the constitutional argument is, the constitutional argument is always twofold. There is a violation of due process, and then that is aspect one, and the other aspect is a violation of the right to equal protection under the law. And so we need to address, just to close all these issues out, we need to address the violation, the alleged violation of the equal protection rights that the appellant says he has, and that have been violated by the planning board's decision in case 12-599. And so to expedite matters, I will simply move that the decision by the planning board in case 12-599 violates his rights to equal protection under the law because of bias of the board in the appeal process.
Second.
And it has been seconded by Mr. Deek. So, in order to address this, all I can do is reiterate what the three of us have stated in the previous motion when we talked about the violation of due process. I think the same considerations apply to the alleged violation of the appellant's equal rights, the right to equal protection under the law. And first of all, I do not find that there's anything in the record that demonstrates that the board violated the appellant's right to equal protection under the law, because the board allegedly is biased, as is the appeal process. But having said that, I do agree that this is something that perhaps needs to be addressed by a different board, and so there's a question of whether we can address that question at all. But to the extent that we can, I think the gist of the motion is that we do not find anything in the record that indicates to us that we need to address the decision reached by the planning board on the basis of the allegation that the appellant's right to equal protection under the law has been violated because the planning board is biased, or the appeal process itself is unfair or biased. So that's my statement. As the one who made the motion, Mr. Deek.
Yes. the motion is to weigh whether Mr. Birnbaum's equal protection right to equal protection under the law was violated by the planning board's bias and bias inherent in the appeal process, as I guess contested by Mr. Birnbaum. And again, we are back to the same issue which we had in the last 2 or 3 motions, which is the development process is inherently biased because it's about development. Not having development will not create a bias. So immediately when you address development, you are biased towards development. So you could argue that the whole process is biased. And I would probably then agree with that, because the whole point of development is that you do it, and then the whole point of creating policies which then able to administer it are made to address other interests which may have a conflict in terms of this bias. So I think we have been looking at that issue here for several motions now. And I think it's something which, as Mr. Chair stated, something to be addressed, and I think it would be a mighty good time to do in terms of the planning board's management of the planning process, and in terms of the administration's management of how they choose and select members who can uphold their positions and administer the planning board process according to the law, and in addition, not to cause perceived a real conflict by the people who are not directly developers, but they are affected by development. With that statement, I would also then follow up, like in the previous cases, that the Board of Adjustment does not have any standing in addressing this issue. We do not have any standing in finding ourselves in a position to come up with any kind of way to address the issue of right to equal protection. And if even we were to do so, the record does not have any kind of information in it which tells me that this inherent bias and the bias of the appeal process is detectable and could be supported by evidence for the record. So with that, again, we are in this position where we're looking at an issue which we cannot necessarily address based on our call, but we may feel that it's perhaps a worthy issue to address. But at the same time, based on what's in the record and what's in our call, we do not have any way to move on this motion or to act on this motion except by denying it. So my stand on that motion is denied.
Thank you, Mr. Stewart.
I concur with Mr. Diak's comments, and I see nothing in the record where his equal protection complaint is supported, and I also believe that this is probably one of those things that it's not within our authority, or as counsel would say, it's not justiciable in front of us.
Thank you, Mr. Stewart. Any further comments? I take it, Mr. Wheeler, you incorporate the comments that you previously made to this motion as well.
Yes,
Is
sir.
that right?
Yes, sir.
Okay. All right. So, having no further discussion, Mr. Deek,
No.
Mr. Stewart, I have nothing further. So then, the matter rests with the board, and it's based on the comments of myself, Mr. Deek, Mr. Stewart, and Mr. Wheeler. Madam Clerk?
Mr. Kuchar?
Nope.
Mr. Deek?
No.
Mr. Stewart?
No.
And the motion fails by a vote of 0 yeas and 3 nays. Now then, there is a matter that was brought up initially, and that is a motion regarding Mr. Spinelli, that there was apparently, and nothing that we discussed so far addresses the issue by the appellant that the application is incomplete and false or misleading because Spinelli doesn't own the entirety of the property at issue or is not the authorized agent as required by AMC 2103-021. And Mr. Wheeler is the one who brought this to my attention, and in order to perhaps, well, how do we do this? How do we say this properly? Just to be on the safe side, I think we need to address that issue of the application and the allegation by the appellant. So, does that address your issue, Mr. Wheeler?
Yes.
It does?
If
All right.
If
So
there's a motion, the normal course, yes.
I will simply move, in terms of, I'm looking at the time here, I'm simply move that the application is incomplete and false or misleading because the applicant does not own the entirety of the property at issue or is not the authorized agent as required by AMC 2103-021. May I have a second? And it has been seconded by Mr. D. And give me a second to confer with counsel where the address is here. The motion that I just made. Oh, well, that's simple. If I can just get my fingers on that. Okay. Let me address that motion briefly. The allegation by the appellant is that Andre Spinelli does not own the entirety of the subject property or is not the authorized agent for the property, citing AMC 2103-020D1, which reads, when an authorized agent files an application under this title on behalf of a property owner, the agent shall provide the municipality with written documentation that the owner of the property has authorized the filing of the application. And Mr. Birnbaum, the appellant, alleges that the application is incomplete and is false or misleading because the applicant does not meet those requirements under the code. And the argument by the appellant is contained in notice of appeal at R024 and R26 and in the reply brief at page 6. So there we are. I must tell you that this issue was not raised at any time in this matter, and this is the first time that he comes forth with this. He could have easily raised this when he appeared before the board or when he made written comments, which he did quite extensively. And it is for that reason that I believe that he is untimely with his objection, and that the motion must be denied for that reason. The appeal from a director's determination that an application is complete and not within the listed items for appeal to this board. The code sets out specific items that we can address, and this is not one of them. And the appellant should have addressed this issue in a different manner, either by contacting the planning director directly and saying, hey, the application is defective on its face, or because he wished to appeal the director's decision, and there is a way of doing that. So in this case, the director of the planning board, of the planning department, determined that the application was complete and complied with the code requirements. Well, if that's not the case, the appellant should have challenged that, and there's a procedure to doing it. Having failed to do that, and having failed to raise the issue when the matter was brought to the planning board, I believe the appellant has waived it and that the motion must fail for that reason. Mr. Deek.
Yes, this one is actually, the best to the last, right? So this particular issue to me is a little bit more complicated than you stated at this point, adding a few layers. One is that if we go forward with this motion and deny it, then we basically, as a Board of Adjustment, we took upon ourselves to correct a procedural error which was made in the process of the application of the plan. Now, I do not see anything in the record which tells me that the procedural error exists. On the other hand, I do think that it is something which we definitely have to know whether it is true. I don't have the materials to tell me whether at the time of application the land ownership standards or the land ownership status was such that Mr. Spinelli could or could not represent all landowners regarding this application. That could be something which we either can resolve by having that information, which I did not, or I wasn't able, or we have the way to address it that as far as the invalidation of the planning board action because of this issue, I think it's onerous. I don't think there is a reason for us to believe that Mr. Spinelli ad hoc acted on behalf of property owners who did not give him authorization to do so. On the other hand, I would like to make sure that we do cover ourselves in terms of making sure that any kind of procedural errors which then developed through the planning process be addressed in a way that it's proper. I may even consider to say that if this is something which is true an error, it could be addressed by the planning board by simply requesting the material from the applicant. I don't think that would be an issue if this is truly the case. But I would like us to talk about that so we don't act without knowing that this procedural error exists and whether we approve its existence. I don't think we should act on behalf of the planning board and cover their shortcomings. With that, I do not think that this is an issue which should negate the decision made by the planning board, and the original motion is to that effect. And I would not support the original motion, which states that Mr. Spinelli's representation is basically nullifying the decision made by the planning board. I do not agree with that statement.
Thank you, Mr. Deek. Mr. Stewart.
I think we've said it all at this point. This is not something that the board should be handling. And he had the opportunity to raise it. There was the structure that was available for him. It was not utilized. And I don't think it's within our responsibility to pick it up and address the issue at this point. I will vote against this motion.
Thank you, Mr. Stewart. Let me just circle back to this for a second. I must tell you that the gist of the motion is basically, do we have any evidence in the record that we can consider that the application is incomplete or false or misleading? And I didn't see any, and apparently neither have you. And that is simply the gist of the motion, and it does not address anything else. If he has a complaint that Mr. Spinelli was not the authorized agent, he should have raised it elsewhere. We are not the appropriate body to consider that because we don't have any evidence that supports that contention. So that's my point, and that is why I intend to vote against the motion. Simply leave it at that. Now, let us turn for a second to Mr. Wheeler. What we have said so far, and the way the motion is worded, is Is that adequate to address the issue as far as you are concerned?
Through the chair, in terms of disposing of the issue as to whether or not the board is going to find the application incomplete for these allegations, yes, it results in my lingering concern is the statements by Mr. Deek about what I think he's saying is he might consider some sort of inquiry or remand to the planning board to confirm whether Spinelli had the authority. And I think based on your statement regarding the absence of anything in the record, I'm not sure that request would be well taken. Because there is, as the chair indicated, nothing in the record to indicate he did not have the authority. If that is the record before you, and that's what you're confined to act upon.
Thank you. Mr. Deek, would you address that once more, please?
Yeah, I would, and I'm
Very
thinking
quickly.
here, because that's exactly why I brought it up. As I said, nothing in the record states to me that this application was illegal, basically, by not having the proper authorizations. On the other hand, we have an appellant which alleges that, which I also have no way to validate or invalidate. So I can narrowly focus and say that I do not have any kind of issue with the record in that regard. Therefore, I would not support the motion, which is where I intend to go. I just wanted to make sure that that this will not be an issue which can come back, perhaps, to us in a case. I'm not sure in what mechanism. That is why I raised it. But I am actually content with Mr. Wheeler's statement that we are tasked with a review of the record and with specific processes, and within that process, I do not see any justification for the support of this motion. And never say never. If I am wrong, hopefully that comes out. But in this case, I would say that I do not think that I am, and I will not support the motion.
Thank you so much. If there's no further argument, the motion rests with the board, and the decision will be based on the comments of myself, Mr. Deek, Mr. Stewart, and Dennis Wheeler, our attorney. Madam Clerk?
Mr. Judicial?
No?
Mr. Deek?
No?
Mr. Stewart?
No.
The motion fails by a vote of 0 yeas and 3 nays. All right. That brings us presumably to the end of issues. And so the only question that is lingering in my mind is whether we need to make a motion on the basis, whether we need to make a motion to deny the appeal of the appellant on the basis of the decisions that we have reached regarding the issues that we have discussed. And so the question is, Mr. Wheeler, should we do that, or is it not necessary? I'm looking at the clock, because in 3 minutes, well, I don't want to say that what's going to happen, but it appears to me that we're going to get cut off. Is that true, Madam Clerk? Or can we sit here for a few minutes longer?
You have the option to extend by motion of the board.
Okay, all right. Well, I will then move that we extend the hearing date, the hearing time from 2 o'clock to 2:15.
Second.
It has been seconded. Any discussion? I would vote in favor of that motion because there are a couple of cleanup items that we need to address, and my motion, if passed, will give it that time. So I intend to vote in favor of the motion. Mr. Deep.
Yes, in the interest of everyone involved, we should wrap this up today, so I will support the motion.
Thank you, Mr. Stewart.
I think we should call for the motion, or call for the
Question.
question.
All right, Madam Clerk.
Mr. Judicial?
Yes.
Mr. Deek?
Yes.
Mr. Stewart?
Yes.
Thank you. And the motion passes by a vote of 3 yeas and 0 nays. and the time to consider this matter is extended to 2:15. Now, let's get to Mr. Wheeler and see what he wishes us to do at this point.
Thank you, Mr. Chairman. One, I would like a minute or two to review my notes to make sure we haven't missed anything. And then two, I would recommend that you make a motion. In this case, based on your prior motions, it would be a motion to affirm the decision of the planning board, because the code requires at 2103.050, I don't see the letter, but ultimately subsection 12A, the Board of Adjustment may, by majority vote, affirm, modify, or reverse the decision. So I think the best structure is to move to affirm the planning board decision, because you have disposed of all the issues, assuming I don't have any lingering ones in my
All
notes.
right, and should we simply go off record for a moment to enable you to look at that?
Fine.
So, done two. And just to be on the safe side, I think having considered all the motions and the voting on motions that we made regarding the appeal, I think one final item needs to be done just for cleanup, and that is there needs to be a motion that the Board of Adjustment affirms the decision by the Planning Board reached in case number S-12599. And I will so move, and Mr. Deek will second that. And the reason that I'm making that motion is this is a complicated case. It is lengthy. The record, if you look at what I have here, what you have there, is very complex. But I think there needs to be something on the record that indicates the final decision by this board, that on the basis of votes that were previously recorded on various motions, that the board does not believe that the appeal has been successful, and that we therefore need to confirm the decision reached by the planning board. So that is why I made that motion, and if Mr. Wheeler is satisfied with that, I will leave it at that.
Okay.
Thank you. Mr. Deep.
So just to repeat, the motion is to affirm the planning board's decision of case, the amendment.
S-12599.
That one, yes. That's the motion. Okay.
Yes.
Thank you. So yes, Mr. Chair, I do believe that it is an important aspect of our action today to make a statement on a final statement based on our review, and I believe that review or that statement is affirmation of the planning board's decision, and I will support it.
Thank you. Mr. Stewart.
I intend on supporting this motion.
Okay, thank you. One final word. I must tell you that I have spent a great deal of time reviewing all the material that is part of this appeal, and I'm specifically talking about the transcript of the hearing before the planning board, the decision by the planning board, the allegations made by the appellants, the reply by the appellee, and I am satisfied and firmly convinced that the planning board reached the correct decision in this case. And I believe that the votes that we have previously cast on various motions confirms that view. It is for that reason that I intend to vote in favor of my motion. Anything further, Mr. Deek?
I would just add that I would state it a little bit differently, and I would say that the planning board made this decision which is consistent in the laws and regulations of the municipality as they are today.
Thank you, Mr. Deep. Mr. Stewart, anything further? Okay. Madam Clerk, on the basis of the comments made by myself, Mr. Deek, and Mr. Stewart, we are ready to vote.
Mr. Guchak?
Yes.
Mr. Deep?
Yes.
Mr. Stewart?
Yes.
And the motion passes by a vote of 3 yeas and 0 nays. So the only thing that then remains is that we need to discuss when we can get together again to finalize this. As is customary and as is required of this board, we need to have written findings of fact, conclusions of law, and a decision. And what has been proposed is that we meet on Tuesday, December 14 at 10 o'clock, right here. And I hope that that is still agreeable, Mr. Wheeler.
Yes, sir.
To prepare those findings so that we have adequate time to review it beforehand.
Yes, sir. My intention is to send it out Sunday night.
All right, thank you very much. And Madam Clerk, you are available, or somebody from your office is available on Tuesday?
Yes.
Thank you so much. And both Mr. Deek and Mr. Stewart and I, we are available. So there it is.
Do we have to publish this? Do we have to publish the meeting?
It has to be published,
Yes.
and it's
Okay.
going to be, Jen is good at that. She knows the rules, the drill, so to speak. And so that's what it is. We will simply reconvene here on next Tuesday, December 14 at 10 o'clock. Final item, first of all, are there any comments by board members at this point?
No.
Mr. Deek says no. Mr. Stewart?
I just appreciate your work that you put into this.
Not yet, not yet. Don't say it. We're not done yet.
Oh,
We will not be done until Tuesday.
all right. No comments.
All right. Okay, I have nothing further at this point. And so then the final item is there any member of the public that wishes to address us? Not about the pending case, anything at all? And there isn't a member, oh, there could be somebody on the telephone, right?
Mr. Birnbaum is on the telephone.
Ooh, okay. Anything that a member of the public wishes to address us about, except the pending case? Hearing none, that is it. And without further ado, we stand adjourned until next Tuesday, December 14 at 10 o'clock. Thank you.